Call again at 12:30.
Item 2.
Miss Nanda, please. Yes.
In this case, my lord, the petitioner filed the leave to appeal petition, my lord, against the order of acquittal
Yes.
passed by the Learned JMFC, Keonjhar, my lord.
You see, in these kind of 138, what will remain?
My lord.
What will remain for after? Do you have any instruction regarding this?
No, I have no instruction. I want time.
You obtain instruction. Ms. Asmita Nanda for the petitioner. The Learned Counsel for the petitioner seeks accommodation to obtain instructions as the matter is pending since 2011.
Notice
up-to-date instruction.
notice ta kar di thandu date fix kar
No, आपण तो कॉलेनी बोली बर्तन ताकू खोला है कि कड़ा होची बर्तन कोडी सो कोन थिला बर्तन छोडा आसी
फाइल गुडा मिलु नथिला
करा जो माने रजिस्ट्री रे शिफ्ट कला बेले मिसप्लेस हितला
कि बोधे सेटा मु बहुत तरह ताकू जो मेमो मेंशन करिथिली
जेबे भी आछि आज्ञा नॉन अपीयरेंस ही
से
आपण आगुर आपण मिल नथिले 2013 रे टू 23 रे वर्तमान आपण हमर फाइल मिलुनी दैट इज द सिचुएशन
notice may be issued last next date.
No, there is no point. There is no point. Acquittal, appeal against acquittal. I was asked this question. I can repeat that. See, there is no point in this. I mean, resurrecting these matters.
4 lakhs rupees is involved.
You see, you cannot make out a case because revision scope of very limited scope.
The leave to appeal manner against the acquittal. I understood.
So there are valid grounds for acquittal. You see, there is a reasoned order. They have gone into the evidence, and 138 has this difficulty, but it's a technical offense. Notice it has to be there.
Notice
has to be served. It has to be there. Then denial has to be there. Default has to be there. All those essential ingredients are technical. That is how 138, to some extent, and it's not strictly criminal. It's quasi-criminal.
It is quasi-judicial matter because
so that is the reason court should be more circumspect in interfering in these matters.
No, my lord, is a 4 lakh.
First, you have to prove that there was a legal liability for to pay. Second, there has to be notice.
Yes.
Third thing, there has to be default.
Is here, my lord, because the acquittal is on the ground of notice.
Have you examined the evidence? Have you examined the evidence how the court has arrived at a conclusion that the offense defined in under 1638 of the NI Act
only
could not
one
be made
ground,
out?
my lord.
Sir?
Only one ground. That is the notice is filed. Notice issued after a delay of 4 days. That is the question.
Fair enough.
30.
You see, there are several decisions.
Yes.
That
but
statutory.
there is no delay. There is no delay, but
So
they
there
have,
is no delay. It's not a matter of. I mean, it's a matter of evidence on record. It's a matter of evidence on record. Whatever evidence you produce, it has been shown that yes, there was delay, and court doesn't have a jurisdiction beyond the statute.
my lord,
That is how 138 has been very strictly interpreted because it is quasi-criminal.
my lord,
Because you see, somebody's personal liberty will be curtailed if he's imposed. So that is how the statute has to be followed.
because of the mistake.
4 days,
of lawyer, my
4
lord.
days, or even a minute cannot be deducted.
No, my lord. 4 days means that is wrongly calculated. Showing that
You show that. Don't you see? My sincere request. If I am making a serious submission, straight away come to that point in the judgment where the learned court has erred.
my lord. The last paragraph से कहिचदी
Last no, upon conclusion पढ़न्तुनी. Discussion or finding ta देखन्तु. Definitely, you are agreed by the conclusion. Rejecting the yes.
all the documents have been exhibited.
Please.
Lordship. And
Yes. Which part the court could not notice the document? Where is the error? Where is the error committed by the court? Perversity. Where is the discussion of that?
discussion is at page 6, my lord.
Yes, paragraph?
Paragraph 8.
Yes, read that.
The
The
Learned
first subpara towards the bottom, about
Yes.
4-5 lines.
First sub
But here it is duty of the court to see whether mandatory requirements provided under section 138 of the NI Act are complied with. Please read that. Read Roman 1, 2,
Acha.
3 and 4. Those are the essential conditions required to make out a case of 138.
Yes. That is the law, my lord. He is
So
only
that is
giving
the
us
because
laws.
that is you can't avoid that or evade that.
But
Because
my lord,
court has given a specific finding that 1, 2, 3 has not been satisfied. You go straight away, go there.
but my deposition is that, my lord, I have given,
Again, you are missing, madam.
my lord.
Again, you are missing the point. Page 7. Page 7, subpara. About 10 lines. In this case, could you get it? In this case, the Bank of India. You are in internal page 7.
Yes.
Yes. In this case, the sentence starts with a in. In this case, the Bank of India, Telkoi Branch intimated PW1 about insufficiency of funds in the account on 9/1/2008. But the evidence of PW1, is the prosecution witness, reveals that he sent the notice to the accused on 12/2/2008. This shows that the demand notice was given to the accused in the...
My lord, my papers have been not properly numbered, my lord. Next week I...
No, obviously, after I find out the exact line, what you are saying, 4 days delay.
No, my lord, I am
So
sorry.
you are saying 4 days delay. So that you have to explain. That you know that it is on the 34th day, not 30 days. Then the next page. I am not referring to the page. Then the next page.
That is
The Honorable Apex Court in the case of Shiva Kumar versus Natarajan, reported in 2009, 43 OCR SC. Words 30 days of the receipt of information are significant. Parliament did not use the words for the date of receipt of information. Section 9 of the General Clauses Act is not applicable. Notice was issued on the 31st day and not within a period of 30 days from the date of receipt of information.
that is the...
So general clause, so it is a specific statute, special statute. What is the principle of interpretation?
My lord, that is this rightly say that clause has been given, but the court has not seen the AD as their time.
Madam, court is not to see the AD.
Because the AD...
We are a common law system. We are not a civil law system. Court never enters into any inquiry. If that is done, then the judgment would be perverse. It is the court acts as an umpire. You will produce evidence. You have to prove your case.
Because lordship may see the defendant has not...
Please don't shift. Let us confine to the point that whether the requirement as interpreted by the Supreme Court 30 days has been satisfied or not. No, it has to be dismissed, madam.
I know that if the notice has not been served within 30 days, that will be...
You see, you can argue the matter.
Will be not maintainable.
First the facts.
This case is my lord.
First the facts.
Yes.
First the facts. And you can make out a case as good as the particular person has a case, whatever is the specific
I have
facts.
a case, lordship.
You do not have any case. Do not have any case. By simply saying the court did not consider.
The AD is not there, my lord.
So the AD, the court, please appreciate. If you want, I can dictate the order right now. Court is not a duty to call for evidence.
I want to show that, my lord. Next week,
it is not there. Where you have produced the evidence. So see the exhibits. Then you go to the next page. Since you are avoiding the pages, go to the last page of the judgment. See that.
That is the only judgment is there, my lord. I will take instruction. Only this is the documents.
The Lord Counsel for the petitioner was heard at length When the court is not inclined to the petition, the adjournment is sought for. When the court is not inclined to entertain the petition, adjournment is sought for. When do you want?
2 weeks after.
As prayed for. List on 17/11/2023.
Yes.
Court is not inclined, kati diyo. Madam, don't take chance. Court is not sitting here helpless or hapless.
Lordship, I will want to satisfy
No,
myself also.
No, it's not a matter of argument. You have to be very specific.
My lord.
You have to be very specific in your submission that yes, this is perverse, contrary to the material on record. And please mark what is Exhibit 4.
My lord.
What is Exhibit 4? Just mark Exhibit 1 to 6/1.
Postal receipt.
Yes, the receipt has been produced. And what is Exhibit 3?
Receipt produce কিন্তু date receipt
You see, so again the problem is that now you are trying to develop a case beyond whatever the material was record. This case would be as hopeless as it could be.
My lord, ଗୋଟେ last chance देखिए.
No. You see, whatever I'm interacting with you, because to make you comfortable, I have dictated the order and then I have interacting with you.
My lord, oblige.
Obviously, so I have already adjourned, but you must know where the petitioner stands. What is the case? It has to be in your fingertips. Yes, please. Next.
Item 3.
May I please, my lord?
Yes, please.
And the petitioner filed this application for quashing of a cognizance order dated 10/11/2010, my lord.
Stay tila.
Yes, my lord, stay was there, my lord.
But for the last, after Asian resurfacing 12 years, nothing would survive.
Yes, my
To
lord.
obtain instruction.
I have also not instruction
No,
on the
please.
status of the case, my lord.
स्टे थिला बेल जो कहले सेटा को ऑर्डर टा कहले
17/3/2011.
17/3/20.
Thore, in fact, after that only once also it is next date ହେଇଛି 10/5/2011.
Yes, my lord. Yes,
দুইটা দেখো মোর দস্খত আছে বাট মু সেটা ভুল নোটিং করছে তা
मैं अच्छे मुंह लिखी जी स्टे जी
ঠিক ঠিক আপন ঠিক করছে
17/3 দেখନ୍ତୁ till further proceeding.
আগে আগে
Yes,
So
my
after Asian resurfacing, nothing survives, and in fact, it was till next date.
lord. Yes, my lord.
হ্যাঁ মু আপন ঠিক করছে let him get the instruction my lord.
Yes, that's the point. Mr. Jena,
पंचानन पाणिग्राही पी पाणिग्राही
Mr. Panchanan Panigrahi for the petitioner, Mr. S.S. Kanungo, additional government advocate for the state. The learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions in the matter. As prayed for list on 28/11. Yes,
स्टे में एंट्री मैडम में भी कंटिन्यू
not after 12 years.
यस मैडम यस
Not after 12 years, and Asian resurfacing for
मैडम
two years.
Yes.
Mr. Kanungo will go file. It is not writ appeal is not, so it will take some time to go to Supreme Court. Thus, he doesn't. This judge doesn't read anything. Yes, suppose you see it is still next date on 10/5/2011. Yes. Next.
Item 4.
Your Lordship, this case inadvertently not admitted on 29/7/2011. This Hon'Ble Court granted bail, but this case is not admitted and not LCR called for also. This is arising of the conviction.
Bail has been granted. This is item 4.
Four Lords.
Mr. Satyajit Mahapatra,
I am not-
petitioner,
I have not power there of the association.
on behalf of P.K. Rautray.
Yes, ma'am.
P.K. Rautray is there.
Yes, ma'am.
Satyajit Mahapatra on behalf of P.K. Rautray for the petitioner, Mr. S.S. Kanungo, AGA for the state. By order dated 29/7/2011 in Miss Case number 801 of 2011, bail was granted to the petitioner the CRL granted to the petitioner in the CRL review. Sorry, in the revision petition. Revision petition, the matter has never been taken up. What to do, Mr. Kanungo?
My lord, may I admit it right now and call for LCR as well.
Issue or notice on admission.
Notice on admission also.
Issue notice on admission. The learned AGA, an advance notice appears for the state opposite parties. Informant ko party kariya darkar?
No, no, sir. Just
No,
GRPs.
No formal notice be issued. Copy is there already there.
no.
Let copy of the revision application be served on the learned AGA. 2 copies.
Yes.
Don't. List for admission in its कौन कुहाଯିବ? List for admission as per the year of filing na कौन सेटा केमती करा होची एबे?
Eta
Contact again.
जो लिस्टिंग टा होची एटा कोन year basis रे ना कोन?
এইটা chronologically আসছে year wise আগে
আচ্ছা
যা মু লিস্ট ରୁ দেখুছি
हाँ मूवी तो से बुझिছি list the matter in its chronology. Yes, list for admission in its chronology. Yes.
Item 5,
Mr. Anis Ankur Misra, A. Misra, on behalf of P.K. Misra for the petitioner. Mr. S.S. Kanungo, AGA for the state. The learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions from the petitioner as prayed for list on 11/12/2023.
item 6,
Lordship, unless this case, item 4, LCR call for
I'm sorry, I forgot. The LCR be called for scanned copy be updated.
man.
LCR be called for from so and so in so and so. Specify कर दियो.
item 6,
My
Yes,
lord,
Mr. Nanda.
this case is coming on the against the order of conviction, my lord. The petitioner is already on bail. LCR was called for, my lord. It is listed, kindly be listed for hearing, my lord. Admit
LCR
hearing ପାଇଁ କା ଡାକି ଦିଅନ୍ତୁ.
LCR is there. LCR is there.
Admit ହେଇନି, admit କରିଦିଅନ୍ତୁ hearing ପାଇଁ ଡାକି. They are on bail. He is on bail, my lord. Realization fine भी stay ହେଇଛି.
the state relation of fine and bail both
Both have been.
Right.
Yes.
Oh,
It
admit-
will
but-
list for
But
hearing.
the
my lord.
learned judge must have been something in his mind. Why it has not been admitted? Oh,
At that time, my lord may be wrongly not
no.
written.
not wrong. He's too experienced.
Maybe
He's too experienced. But he must have thought something. He's a veteran. I mean,
it is for
a
hearing.
veteran from the judiciary. So he
Right.
must have thought something.
1 year conviction.
Actually, what is happening, I have also seen that in some matters, they're just calling for after preliminary hearing, they're admitting. Like the other matter, there's no point in admitting that 138 matter.
At that time, it was hard by the court, my lord.
As far as suspension of sentence is something else, please appreciate, because that is rigorous. Unless the sentence
1
is
year
suspended, the petitioner will suffer. So for that, no detailed consideration is necessary. But as far as admission is concerned, I
question
think,
of admission remains open also. এটা এই হেড রে ବି ଆସିଲେ ମେରିଟ ରେ ଆପଣ କରିଦେଇ ପାରିବେ ଯେ
ଦେଖନ୍ତୁ ଆପଣ ସେ କଣ LCR ତ already call for ହେଇଛି, LCR available ଅଛି.
Yes.
LCR available.
ମୁଁ ସେଥିପାଇଁ କହିଲି hearing ରେ ହିଁ ଆଣୁ.
ନା for admission ଆସୁ କି ନହେଲେ hearing ପାଇଁ ଲଖିବେ.
ହଁ.
ଠିକ ଅଛି. Miss Nanda Sasmita Nanda for the petitioner, Mr. Satya Sundar Kanungo, additional government advocate for the state. By order dated 23/3/2012, in Miss Case 289 of 2012, the petitioner was granted bail by the order of the said date in Miss Case number 253 of 2012. The realization of fine was suspended till disposal. Para. LCR has been called for and is available. Issue note lists the matter for hearing in its chronology.
Yes.
Maybe the learned judge was thinking that there is no point in admitting and keeping the matter. So after grant of, I think that's a better strategy also. The petitioner is not suffering because it has been the fine realization has been suspended, bail granted. Only the matter whether it should be entertained or not.
Yes. For 1 year conviction, court wanted to see the LCR.
You have to think that whether the period already undergone.
Yes, I'll.
That instruction you can obtain.
Yes.
Mr. Standing Counsel, that matter you were arguing, that you said that Mr. Kanungo's matter also. Mr. Misra said that he is not aware of the period undergone.
Yesterday matter.
But for probation also, the court has to award a sentence, and by giving a bond, he is going out.
Yes.
And for 1 year and for good conduct, then the sentence is remitted, or he's all.
Oh,
So that part he did not, in fact, address. And the other problem is that when I specifically asked him that what was the period he was, it's not your matter.
Custody.
We are discussing something.
Period under.
Period. He said that I have no instruction.
Yes, madam.
So then I have to find it out. I have to find it out from where, how much time he has already undergone.
Oh, from the LCR.
LCR.
My lord, I got a decision, my lord, for your lordships, my lord.
I have referred to 4 decisions.
Yes.
So around 8:30. So after all this, then I found that suppose it is always a better option to pass an order, because you see ultimately the conviction is sustained.
Yes.
So if it is period undergone, then he doesn't go to appear before the court, give a bond.
Yes.
Yes, that can be done. I mean, we have to start this trend of probation.
Actually, my lord, he submitted during, my lord, he was someday in custody, but after, my lord, the conviction was not in custody. Is what he.
Appellate order has, the last line of the appellate order says that the period will be set off. Usually the learned courts, they look into the brief. I mean, at least the register, because suppose the initial conviction, he must have filed appeal before the learned session judge. So for that period, for few days, he would have been maybe 2-3 days also.
Yes, they must be in custody.
So there, they verify the register also. So otherwise that order, either that order is for in a routine manner, just saying that if any, that it will be set off from the total period of incarceration. And the judgment kindly give it.
My lord. This is only for, my lord, how to, my lord, the order is being passed on Probation of Offenders Act. That is.
No, I have dictated and completed.
Yes.
But that period actually.
Lordship's order was correct. Yesterday, that was.
No, because some words and all that, but that part we did not, it was delayed, of course, it was almost 5.
Yes.
But he also did not say that this court cannot, this court in fact is basically not completely waiving out the sentence. Some sentence is imposed. The section 4 provides up to 3 years. And he files a bond for good behavior and goes out. And then after successful completion of that good behavior.
1 year, my lord.
So it can be 6 months even. Why 1 year?
Yes.
Why 1 year? It can be 6 months even.
It has been given for 1 year.
So you please give that order. Thank you. Upon the
Item 7.
Mr. Debasis Sodangi for the petitioner, Mr. Sangram Das, Standing Counsel Vigilance for the state opposite party. Mr. Sodangi submits that the matter being old one, there is a possibility that in the meanwhile, it would have been disposed of by the learned court in season of the matter. By the learned trial court. Registry shall seek instructions from the learned court in season of the matter regarding present status of the case by the next date. List on 4/12/2023. Yes, next.
Item 8.
Call again at 12:30.
Item 9.
Mr. Satyajit Mahapatra on behalf of Aurobindo Mohanty for the petitioner. Mr. S.S. Kanungo, additional government advocate for the state. The learned counsel for the petitioner files memo dated 2/11/2023 indicating that the matter may be disposed of. Para. The memo is taken on record. The petition stands disposed of. So, Paragolica, the petition stands disposed of. Yes.
Item 10.
Mr. Sangram Das for the petitioner, Mr. Opposite party blank. The learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions in the matter. As prayed for, list on 4/12/2023.
Item 11.
11. Call again at 12:30.
12.
Call again at 12:30.
13.
Mention करथिले कोन आपण परा मेंशन करथिले 13 रे कोन हला
Kindly pass over the
12:30. Call again at 12:30. Yes.
14.
Yes, please.
affidavit is the filed, my lord. That has not. Let it come some other day, my lord. 2 weeks after, let it come, my lord. Affidavit is to file. 14 and 15.
Mr. H.B. Das for the petitioner. Mr. S.S. Kanungo, additional government advocate for the state. Learned counsel for the petitioner seeks further accommodation to
File comprehensive.
take steps for to comply with the order dated 10/10/2023 as prayed for. List on
2 weeks after.
2 weeks after date କରନ୍ତୁ 21/11/2023.
Published.
Yes, next.
15 or 7.
Item 15.
What is the date of order, Mr. Das?
15.
10/10, same order,
Same.
same date. Yes, same order. Mr. S.S. Kanungo.
Published.
With Das, Mr. S.S. Kanungo. Yes, next. Mr. Padhi,
16.
Bhaktilata Bala on behalf of Manoranjan Padhi for the petitioner.
Under section Lordship 302.
The prayer for adjournment is made on behalf of the petitioner. The Mr. S.S. Kanungo, the learned AGA submits that charge sheet has been submitted and there are eyewitness account of the alleged occurrence against the petitioner. Yes. As prayed for, list on 20/11 to grant further opportunity to the petitioner.
17.
Same case.
Bhaktilata Bala on behalf of Manoranjan Padhi for the petitioner. Counsel for the, this is the one FIR.
Lordship.
Okay. Same order. 18. Mr. Das.
May I please, Your Lordship? My lord, petitioners have been implicated, say the 302 of IPC, my lord, on the basis of circumstantial evidence, my lord, that to here's evidence, my lord, and on the
Could you get the deposition copy?
supplied, and that is in the
Yes.
court. And FIR is, my lord, that he has initially his one UD case was registered, my lord. Thereafter, after 14 days, my lord, he lost the FIR, alleging that he heard from the others that these persons are involved in committing the crime, my lord.
ଏଥିରେ ତ scientific evidence ତ ହେଇ ନଥିବ.
କିଛି ନଥିବ ନାହିଁ।
ଆପଣଙ୍କ as per you, in according to your version also there has to be this is circumstantial evidence and scientific evidence is a must.
27 discoveries there.
Discover
The weapon has been recovered, and all the depositions when I've examined, there are 6 PWs. All of them, except one, say that the accused had gone, the deceased had gone to the accused for consuming liquor outside the village for a feast. While coming back, only the accused came back, the deceased never came back.
What is the total period, Mr. Das? Till now, they have been inside.
we have been custody
14/1/2023, they were arrested.
You wait for some time.
14-23,
My lord.
my lord. Lordship.
Should it be adjourned? What is, what is yes.
Adjourn.
Mr. H.B. Das for the petitioner, Mr. Devasis Naik, additional government advocate for the state, AGA for the state, Honorable Counsel for the petitioner, seeks accommodation to advance argument. As paid for list, when do you want, Mr. Das? December.
December, November asu
Quebec, 22/11. Yes. Mr. Achari.
On behalf of Mr. Achari, my lord, adjourn the matter.
Mr. Lambodar Achari for the petitioner. Sorry, Miss Nanda.
On
Yes, Miss Sasmita Nanda on behalf of Lambodar Achari for the petitioner. The learned counsel for the petitioner seeks accommodation to obtain the document indicating, obtain copy of the document indicating surrender of the petitioner on 11/8/2023. As prayed for, list on 23/11/2023. Registry shall call for a report from the court in season of the matter regarding surrender of the petitioner on 11/8/2023 after the period of interim bail as stated. Stop. Yes. Next, please. Yes.
Item 20. May I please, Your Lordship?
Yes.
Initially, the FIR was registered under section 394 IPC.
Yes.
And my lord, section 25-27.
Have you complied with that order of filing?
My lord, regarding the filing of the affidavit, my lord. Just now I am, my lord, filing the affidavit, my lord.
Okay, you serve a copy.
My lord, just now I am.
Mr. Ashit Kumar Jenna for the petitioner, Mr. Devasis Naik, AGA for the state. Learned counsel for the petitioner submits that in terms of the earlier order dated 6/10/2023, affidavit on behalf of the petitioner shall be filed today. Shall be filed
in the court.
Shall be filed today. Copy of which shall be served on the learned AGA to enable him to obtain instruction.
Thank you.
Stop. The affidavit shall be taken on record. The scanned copy be updated. As prayed for list on date korantu. Date. AC.
Short date may be fixed, my lord, because my lord, all are young boys, my lord.
Young boys having criminal proclivity.
They
should be
remanded.
You should be
Remanded.
They will be remanded, sir. As I was discussing yesterday, you never know how many cases is being reported.
Pardon me?
How many cases are reported? With the nature of the people is that they don't report.
Yes.
More so when they are scared of this kind of people. They don't report.
No, natural.
So what is so big deal about being remanded in after being arrested?
No, what is happening, my lords?
Sir, that's
Your lords-
sir, that's a very too skeptical view. You see, nobody is sitting as far as the law enforcement is concerned, just to remand in connected matters. No,
My lord,
that is a possibility. Yes, that is a possibility.
can I file, my lord, the affidavit, my lord? Already I have prepared.
Yes, but I can't break the glass. That is a difficulty.
Registry.
My lord,
It has to be scanned and uploaded. Yes. Let's wait for list on. Aji kete hela?
ଆଜି 2 ତାରିଖ 8
ଆପଣ ଆଗରୁ ଦେଇଥିଲେ ଥାନ୍ତା ଆପଣ 6-10 ରୁ you have taken how much time you see you take 1 month to file an affidavit and you expect them to obtain instruction within a short period. Mr. 13 week ରେ ଆସୁ 14-11 14-11 you obtain instruction, Mr.
Let's have a copy.
The learned 14-11 the learned AGSL obtain up-to-date instructions. What is the status of trial? Charge sheet.
No, charge sheet not, charge sheet submitted.
FPR has been submitted.
My lord.
Up-to-date status of the trial also. Yes.
Trial not commenced.
Okay. Sub-item, same FIR.
My lord. No. And so far another case is concerned, same accused persons, and they have been implicated in another case also, remanded in another case, my lord. Arrested in one case.
7547.
7546
is Sumacharan.
My lord. 7547 is my lord.
So there is no order for filing of affidavit, or there is an order?
I'm also filing, my lord.
Okay, it's the same order.
Same order.
Order ta verify kar debe. 610 bode. 610. Yes. Next. Yes, please, next.
Item 21.
Call again at 12:30. Yes.
22.
22. Yes, please.
May I please, your lordship?
Yes.
My lord, kindly urge on this matter.
Your name, madam?
Shakuntala Ghosh.
Shakuntala?
Ghosh.
Miss Shakuntala Ghosh on behalf of M.S. Shakuntala Ghosh on behalf of S.K. Nath.
Yes, ma'am.
S.K. Nath for the petitioner. Mr. Devasis Naik, AGA for the state. Prayer for adjournment is made on behalf of the Learned Counsel for the petitioner. As prayed for, list on. Again? When do you want? November or December?
November.
By 22/11/2023, Learned AGA submits that the case diary is available.
Case diary, my lords, is not available. I'm calling for.
But here it says, just check it. This is 7702, or I'm holding different brief.
My lord, I'm talking
sorry.
8385.
I'm so sorry. I'm holding another brief.
Okay. 8382.
I'm looking at another brief.
Okay. 8385.
This is item 23.
Right.
This is item
22.
It's the same counsel in both the matters.
22, 23.
The report given by the filing assistant is कौन अछि? कौन भूल अछि? Report टा कोठी अछि? Flag है नहीं, flag है. अरे एफआईआर का डिटेल दिया है नहीं? How many bail applications have been filed?
Total 20.
20 bail applications.
He has 20 cases.
One FIR or different FIR?
Different FIRs.
All are different.
So the ones that I have, there are two different, 367 of 20 and 366 of 20. Jagatpur PS. I have two right now, 22 and 23.
The filing assistant has put up a note as at flag A wherein it is indicated in a tabular form that the petitioner through his advocate has filed bail applications. Stuff. The said table indicates the date of disposal and the name of the honorable judge. Stuff. However, the FIR numbers have not been mentioned in that list. The filing assistant has to be cautioned for this casual approach, as such a table doesn't make any sense in view of the specific order passed by the Honorable Supreme Court in Jani. What is that Jani, Mr. Standing Counsel? Full name of Jani?
Jani.
Anyway, Jani everyone knows.
Yes.
The registry at least they know it. In view
Yes,
of
Jani or
by the
DS?
Honorable Supreme Court in so and so Jani. ବୁଝିକି ଲେଖିଦେବେ।
DS
ଆଚ୍ଛା ଏପଟ ଲିଷ୍ଟ ଗୁଡ଼ା ଦଉଛନ୍ତି କାହିଁକି ତାହେଲେ ଆପଣ ଯଦି ଏଫଆଇଆର ନମ୍ବର ମେନସନ କରିପାରିବେନି ତାହେଲେ ଲିଷ୍ଟ କଣ କରିବେ ଜଜ୍ ଦେଇକି ଖୋଜିବେ ରେଜିଷ୍ଟ୍ରି ମୁଁ ଆର ପଟକୁ ପଳେଇବି ତାପରେ
That order is not there, but
the Honorable Supreme Court in Pradhani Jani.
criminal appeal number 1503 of 23 arising out.
Sorry, could not hear you. Criminal appeal number.
I'm sorry. Criminal appeal number 1503 of 2023 arising out of SLP
1503 of 2023.
arising out
That's it.
at SLP criminal number 3241.
Because it has already been converted, so SLP number is not necessary. The Pradhani Jani, they are aware because every day we are facing that difficulty in listing.
That standing order reflects that.
Yes, standing order is there. But since I do not know, and Mr. Naik says that it may be a different affair.
In fact, the two that
So in fact, all the four judges, including me, we are really at a difficulty.
Yes,
Do not know which matter is being listed. As per this list, there are 3 honorable judges. I am the 4th judge.
Lot of
Yes.
confusion.
Sorry?
Lot of confusion.
Item 23,
23 similar.
Madam, the same, that list. ଆପଣଙ୍କର କନେକ୍ଟେଡ ମ୍ୟାଟର କଣ ଅଛି ଆପଣ ଯାହା ଭିସି ରେ ଯାହା କିଛି କହୁନଥିଲେ ମୁଁ ହେଲେ ଆପଣ ବୋଧେ କଣ ଡିଫିକଲ୍ଟ ଅଛି ଏଠି ବି କିଛି କହୁନାହାନ୍ତି standing order 2 of 2023 21/5/2023 please go through that standing order because suppose I pass any order contrary to that standing order then it will be non-est. Same order kar diyantu je the learned counsel for the so and so on behalf of so and so. So Devasis Naik for the petitioner. I'm sorry for the state. Has prayed for list on.
by sale.
Case diary is available.
no man.
The learned counsel for the state shall obtain case diary. DT jagare karte huye. And the earlier matter also both matters case diary to be obtained. Yes. Same date.
Yes, ma'am.
Yes.
24,
May I please, my lord? My lord,
Yes.
concern 20B2 से NDPS Act, my lord.
On quantity 120 grams of brown sugar.
No, my lord.
Then?
445 kg
Ganja.
ये
What
my
can-
lord, ये usually co-accused, my lord. Main accused is he already released on bail, my lord. Only co-accused statement, he is implicated in this case.
Then I can take up the matter. If already the bail has been granted by you are saying by the sessions court.
Sessions court, my lord.
So this is a pre-charge sheet or after charge sheet?
No, PR pore, my lord. After PR, my lord.
Sir, filing the rejection of the bail before the learned trial court is pre or post final APR?
Post, my lord.
When APR is submitted?
My lord, PR submitted on dated 25/2020, my lord.
25/7.
5, my lord.
25/5/2023.
20, my lord. This case,
20.
my lord, 20, my lord. 2020.
He's in incarceration since he's in custody since
Custody since, my lord, 6 months, my lord.
then he was arrested after the FPR was filed.
My
He
lord.
was absconding.
Absconding, my lord. And we will issue against the present petitioner, my lord.
Gangadhara Naik, he's a co-accused.
No, my lord. Patito Vishwas, my lord. Co-accused, my lord, Mahadev Vishwas.
FIR number? Trial number?
TR number 15 and 15 2018, my lord.
So there is an order by another coordinate bench of this court. Are you aware?
My lord.
Sir, are you aware that there is an order by the coordinate bench of this court regarding Gangadhara Naik? Malkanagiri Special Judge, TR number 15 of 2018.
18, my lord.
Disposed of on 3/12/2019.
In this case, my lord, main accused.
अरे आपण मु गोटे कथा कहले
Petitioner is brain hemorrhage, my lord. Suffering from jail, my lord.
ब्रेन हमेरेज ହେଇଛି ତାଙ୍କର
My lord.
କାହିଁକି ହେଲା
Medical report, my lord, ସବୁ ଦେଇଛି, my lord.
ତେନି ସେ ତା ଟ୍ରିଟମେଣ୍ଟ ହେବେ ତାହେଲେ
ହଉଛନ୍ତି better treatment.
ଆପଣ ଜାଣିଛନ୍ତି ଆପଣ ଯୋଉଟା ଏକ ପ୍ଲି ନଉଛନ୍ତି the plea you are taking that's not a short term disease. He has to be treated by the state in custody. It's not a short term disease. And you must know that the lauded bench which passed the earlier order, that bench has sentenced somebody for filing false affidavit. IA at flag A.
IA, my lord.
Copy.
You know, I have filed affidavit regarding criminal antecedent, my lord. Affidavit भी my lord file कराई criminal antecedent देना नहीं भी किसी.
Discharge केबे हेले अरेस्ट परे डिस्चार्ज हिचंती
जेल रे थाई कि माय लॉर्ड तांकर ब्रेन हेमरेज हिची
सर आपण देखु नांती दैट्स ऑल प्रॉब्लम हाउ लुक एट पेज 8 of your IA.
My lord.
What is the top? What is what you can read at the top?
Discharge, my lord.
Then when I ask you, you are saying something else. Mark the date.
My lord. 12/8/2023, my lord.
Yes. Then discharge date. Sir, if you can read 12/8, then you cannot read the next line.
My lord.
What is the next date?
13/8/2023, my lord.
Yes. So obviously he was not admitted even. He was referred to the MKCG Medical College.
My lord.
Then what happened? When did you file the petition? Have you served copy?
I don't have a copy of either the affidavit or the IA. Let him serve copies of both. I'll call for the CD and CA also, my lord.
Have you not served copy?
My lord.
This is BLAPL 8494 of 2023.
My lord.
But anyway, since I may not take up the, I would not be able to take up the matter because of the learned counsel for the petitioner submits that he has filed IA 1152 of 2023 for grant of interim bail for treatment of the petitioner due to his medical condition. Copy of the same shall be served on the learned AGA to obtain up-to-date instruction. Copy of the affidavit also shall be served on the learned counsel for the state. Affidavit dated 9/10/2023 regarding past allegations of criminal activity against the petitioner. Shall be served on the affidavit regarding so and so shall be served on the learned AGA to enable him to obtain instruction. It is indicated in the details of lower court cases out of which the present case arises, that BL APL number 1083 of 2019, Gadadhar Nayak versus State of Odisha, bracket closed, arising out of Malkanagiri Special Judge Malkanagiri TR/15/2018 was disposed of by order dated 12/3/2019. That is 12/3 or 3/12? Is your entry ta? Lower court case number देखो तापर disposal date जो अच्छी 12/3. First is year, then month, then date 12/3/2019. The present BLAPL, that is 8494 of 2023, is in the present bill 8494. It is also indicated that the case arises out of Malkanagiri TR15 of 2018. Office to verify and do the needful for listing of the matter before the appropriate bench as per the standing order 2 of 2023. Yes. The learned AGA shall obtain instructions in the matter. In view of the urgency of listing, as the petitioner has filed an IA, the registry shall take immediate steps. Yes. Yes. Next.
25.
Mr. Pradhan.
376 2N.
That matter which I suggested that you obtain instruction if anything is possible.
Yes, yes.
Yes.
Order dated 18/10/2023.
Yes.
Yes,
You are for the
since-
informant.
My lord, I am appealing for the information.
Yes.
Since
What is
all
the-
the family members of the petitioner have been included as an accused,
Mhm.
and moreover, the present petition is
No,
languishing.
they have not been granted
4/7.
bail.
My lord?
They have not been granted bail. The other family members. I mean, how many persons are in custody in this
The
present?
only blood
The main accused.
main accused
Mhm.
is in custody,
Hmm.
but other family members have been added as an accused in this case. I mean, of all family
That
members.
is usual. In these kind of cases, actually, what is happening? You try to file it early,
Yes, yes.
so that they can
Earlier
obtain
I
instruction.
filed this
Yes,
after serving copy.
yes. 8 or 9 रखी दियो 9 9/11 sir 12 आपण कर देले कौन we are in November.
26.
Yes.
May on behalf of Mr. Lenka, my lord.
Yes, please.
Oh, Lordship may kindly have a glance. Just. So Lordship may kindly have a glance over the order dated 15/9/23.
Just a second. Actually, something is obstructing.
So Lordship directed the IO.
डिलीट होनी चाहिए तो डिलीट कर दो Yes. $15,900. Yes.
Miller, your lordship directed for filing an affidavit with the nature of allegation
Allegation and road subscribed to the present petition.
Miller.
Yes.
That the IO is present today. I have got the draft affidavit, Miller.
Yes. You go through that, finalize it and file it.
Miller. Your lordship grants some time
Yes.
so that it can be filed within it. By
You are seeking adjournment on behalf of?
Mr. Lenka, my lord.
ଆପଣଙ୍କ ନାଁଟା sir?
KC Behera.
KC Behera on behalf of SK Lenka for the petitioner, Mr. B. Bhuya, standing counsel,
Special
counsel for the state, into bracket OPID capital. ଆପଣ କାଲି state counsel को नाम सब छाड़ दीजिए. Mr. Praharaj, you always be ready with your list because he is leaving late evening. I am not disturbing you.
They always.
Special Mr. B. Bhuya, Special Counsel OPID. Learned Counsel for the petitioner seeks accommodation. The Learned Special Counsel submits that in terms of the order dated 15/9/2023, the affidavit has been prepared and shall be filed and seeks a short accommodation. 21.
After
How much time, sir?
Next week, man.
Upon instruction nahi pariyo next week dele.
Yes, my lord. Already charge sheet already filed. I obtained the charge sheet.
In these kind of matters, you know what is the trend in this High Court at least. What is the money and how much you are, because I don't know why you are wasting time like this. Masa pare affidavit file kurchonti, tapare copy serve kurchonti, tapare instruction niya hochi. You should tell the petitioner, whoever the lower court counsel or whoever the relatives. The copy of the affidavit be served on the Learned Counsel for the petition. List on 8 or 9, when do you want? Or the week commencing 13?
13.
As spread for list on 13/11/2020.
Hon'Ble.
Yes.
27.
Call again at 12:30.
28.
28, my lord. Kindly taken up next week, my lord.
Mr. S.K. Patnaik for the petitioner. Mr. Devashish Naik, additional government advocate for the AGA for the state. When the matter was last taken up, on 16/10/2023, the Learned Counsel for the petitioner sought for accommodation to comply with the order dated 31/8/2023. Stop. Today, further time is sought for 21 as spread for
10th.
List on 10/11/2023. The Learned AGA submits that case diary is available.
Obliged.
29.
29, may I please, Lordship?
Yes, please.
Lordship, here the petitioner is in custody
Yes.
since 37/2023, my lord.
Yes.
Here the alleged offences under section 20B(2)(c) of NDPS Act, my lord. Here 23 kg of ganja, my lord, seized from the present petitioner. And the present petitioner having one similar type of criminal antecedent, I have filed affidavit, my lord.
We sought copy of the affidavit.
Yes, sir. I have, he says one, but my instructions are none. So probably it's a one. His affidavit reveals one antecedent. My instructions, in that there are no CA. There is no CA.
Actually, the present matter is by the police or by the excise?
Excise, 2cc case, my lord. Both are 2cc case.
Both are 2
my lord.
Okay.
Previous one is 8 kg. This one is the 23 kg.
So he is increasing, he is doing good progress. What is his age?
Age is 28 year, my lord. Young boy.
So he's safe. He's safe at least. He's not further graduating to 82 kg.
No, my lord.
So your instruction is in sync with his affidavit. That is your submission. Mr. Your name, sir?
S.R. Panda.
Mr. S.R. Ponda. For the petitioner, Mr. Devasis Naik, additional government advocate for the state. This is above commercial quantity.
Yes.
Just
But how is it that everywhere when the brown sugar is seized, it is below commercial quantity? So it is actually it should be redefined. Money terms.
Yes.
Money terms, brown sugar you are seizing around 500 kg of ganja equivalent. So 30 grams, 20 grams, usually 120 grams. And ganja, there is no point because it is not economically viable to transit 1 kg ganja.
Yes.
Most shocking part is that. Most shocking part is that is in custody since
37 2023.
37 2023. Final prosecution report has been filed on.
It's not yet filed.
Not.
Then how you are pressing now? You should adjourn it. That is the only ground these commercial quantities is allowed, or the coordinate benches are allowing without filing up APR. Yes, Mr.
In some
Yes.
that is being done since just above the commercial quantity.
Without filing up the APR.
Yes, that.
At least I have persuaded him. You did not argue that point. That the discrimination in carrying ganja and
Up to 30 kilo, Lordship.
even more than 30 kilos, sir. So I have the petitioner has, though there is one earlier allegation against the petitioner, the petitioner being young, given a chance, he shall not, given a chance, he shall mend his ways, and there is a greater chance of he being reformed by coming into the mainstream of the social life. This further submitted that petitioner being a local resident, having roots in the society, shall subject himself to the jurisdiction of the court in season of the matter. The learned AGA, referring to the case diary, opposes the prayer for bail, also referring to the provisions contained in section 37 of the NDPS Act. Having had learned counsel for the petitioner and the learned counsel for the learned AGA for the state, this court is inclined to grant bail to the petitioner, subject to such stringent terms and conditions that would be imposed by the court in season of the matter, which shall also include a condition that any violation of oblique deviation from any of the terms and conditions shall lead to filing of petition for cancellation of bail by the law enforcement agency, disposed of accordingly. Please explain him. It is a harsh condition, but he has to be put under tenterhooks. Yes.
Deeply obliged.
Yes. 12:30. Call the Passover matters.
Passover item 1.
None appears for the petitioner, though the matter is called twice over. Once at the beginning when the matter reached, and again at 12:30 p.m. So Kanungo, what to do? And further opportunity.
Last between private parties also.
Appearance like you, Mr. S.S. Kanungoji, to grant further opportunity.
Item 2 state na.
My lord, in item 1, my lord, I am for the opposite party.
Mr. S.S. Rai, Mr. S.S. Rai for the opposite party. What do you say, Mr. Rai?
My lord, they have challenged this, my lord, against the order of acquittal, my lord.
So let us grant some time. Let us grant some time. Let us see.
My lord.
The leave has not yet been granted.
Yes.
To grant further opportunity, list on 5/12/2023. Yes, please. Next.
Item 8.
First paragraph saman rahiba. Same paragraph, first para. Then to grant another opportunity, list on 6/12/2023. Next, please. Appearance the non other side state by Mr. S.S. Kanun. 8 Mr. S.S. Kanun for the state. AGA for the state. Yes. Next, please.
Item 11.
First paragraph saman rahiba. Mr. S.S. Kanun AGA.
More. No. More put pass. Sorry.
This was earlier rejected. Okay. Justice Pujari, since he has retired, so it can be listed.
It can be heard by you also.
To grant further opportunity, none had appeared when the matter was taken up. None had appeared for the petitioner when the matter was taken up on 11/10/2023. To grant further opportunity, list on 15/11/2023. Yes, next, please.
Item 12.
First paragraph same. To grant further opportunity, list on 15/11/2023.
13.
It was there, somebody was mentioning on behalf of Mr. Das. First paragraph same, none appears for the petitioner when the matter is called twice over. Complete the paragraph. Mr. S.S. Kanun AGA to grant further opportunity, list on 14/11. Yes, next.
21.
First paragraph. None appears for the petitioner, though the matter is called twice over. Mr. Devasis Naik AGA for the state appearance likhibe. None had appeared when the matter was taken up on 5/10/2023, 28/8/2023. Apparently, the petitioner is not prosecuting the matter. Case diary is available.
No, my lord. No.
Apparently, the petitioner is not interested to prosecute the
It's
matter.
there, it's there, it's there, it's there.
To grant further opportunity. List on 13/11/2023. The Learned AGA submits that case diary is available. Yes, next.
Item 27,
Yes, please. Be careful. Yes. Yes, please.
Sir, previously affidavit was filed.
Have you filed?
Yes, previously it was filed.
When, sir? When did you file? This is item 27. 8952. I don't find the affidavit in my record actually. When did you file, sir?
Sir, that was on 17 sir.
1710 you have filed the affidavit.
Yes.
Have you served copy?
Sir, copy actually another lawyer was
So
there.
whenever you file the affidavit, you retain the this receipt. Registry receipt is there, and the AG office receipt should be there, so that we are not discussing these things whether filed or when it was filed. Or receipt देखुना नहीं केबे file कले?
Sir, on 17 but he is not conducting lawyer is not there today.
सेटा कहिबे ना, how do I know, sir, you are not the conducting lawyer? Your name, sir?
Satyanarayan Panda, SN Panda.
Sir, you are the conducting lawyer.
Yeah, another power is there actually.
Only Satyanarayan will appear. Whoever is Satyanarayan.
Sir, actually he was looking after the case.
पंडा कौन सर आपण प्रधान कर देले से प्रधान कर देले आपण मिस्टर सत्यनारायण पंडा फॉर द पिटिशनर मिस्टर देवाशीष नायक additional government advocate for the state learned counsel for the petitioner submits that आपण तो definitely कहना थी मैं order भी लिख परिबिनी. That's the difficulty since you are unable. अपन यदि file
I may be permitted to withdraw the case, sir.
No. The learned counsel for the petitioner seeks accommodation. If you have filed the affidavit, you tell that, and he is also not having the copy.
Date exactly not known to me, but it was filed.
Obviously, you have to have that receipt so that I can record that. The learned counsel for the petitioner seeks further accommodation to verify if the order earlier order dated 31/8/2023. Directing affidavit on behalf of the petitioner to be filed, indicating the criminal antecedents has been filed or not. As spread for list on
sorted.
So yes,
1411. Yes, sir.
List on 1411. Yes. Yes. Next.
item 30,
Lordship, on behalf of Mr. Chan, praying date for next week, Lordship, to file the comprehensive affidavit.
The matter may be listed before a bench where M.S.Sahoo J is not a member. Your name, sir?
Shrikant Gowda, S.K. Gowda, Lordship.
So S.K. Gowda for the petitioner, Mr. Devashish Naik AGA for the state. Yes.
31.
Much obliged.
Yes, please.
Lordship, kindly allow me. Lordship, kindly allow me.
Sir, you are technically, sir, I am not competent even to blank the screen. So you are already there.
Yes, Your Lordship. May I please, Your Lordship?
Yes.
Your Lordship, the present allegation is that the assault against allegation is that the two brothers involved in the property.
You have filed the affidavit. Complied the order, earlier order passed by the coordinate bench.
No order relating to affidavit, Your Lordship.
Okay. Have you received case diary and antecedents?
No, ma'am.
Please check it. This is because this is an old order.
It is
22/9 case diary was called for.
It is tagged to 7981 ABLPL, but that ABLPL.
So no, you have to get the up-to-date diary.
No, that
apart from that, you can get that file.
My lords, that has not come.
Mr. R.R. Rai for the petitioner. It's a hybrid mode. Hybrid. So what is the hybrid? Mr. Devashish Naik, additional government advocate. The learned counsel for the learned AGA seeks further accommodation to obtain the up-to-date CD and instructions. If you have anything or if you do not have anything, you can file that affidavit. But the petitioners are not cooperating, so that is how after the case diary is received, you are filing that affidavit.
Your Lordship, see the situation. Two brothers involved. I am in group of another brother, Your Lordship. I am inside custody from 8 persons. All others are free.
Sir, equality, you are saying equality as far as bail is concerned. That concept is yet to develop, sir.
Your Lordship, I am
similarly situated persons can claim.
Your Lordship, I am in 4
But every time the exact this overt act attributed or all those things are to be considered.
I have no antecedent. Even the
Sir, what is the overt act attributed to you?
Your Lordship,
rejection order.
Yes, Lordship, kindly see page 8. Your Lordship. I'm coming to page 9. Your Lordship.
Bleeding injury on head, fracture both legs.
Yes.
So what has been attributed to you? What you have done?
मोर भाई एवं प्रशांत बराल तार निज भाई एवं प्रशांत बराल दी प्रेजेंट पिटिशनर दुई गोड़ भांगिले and no
sir, that fracture is attributed directly to you, that you are yourself saying.
Two persons involved. मोर भाई एवं प्रशांत बराल दुई गोड़ भांगिले. Who assaulted, who actively participated?
Sir, मो भाई माने कोन माने
तार निज ब्रदर
अरे प्रशांत बराड़ गोड़ भांगिले जले आपण जदी कहबे ताले what else the court can do? अपन कहे मु भांगिनी प्रशांत बराड़ त भाई भांगिले. You are making a distinction.
Yes, your lordship.
सेमती करा जाय नि सर, क्रिमिनल लॉ सेटा नाही.
Because your lordship, my wife,
when there is a specific statement attributing something to you, you make it's a matter you can disprove it in the trial.
Your lordship,
the bail, that is how your bail has been rejected.
I bought
and the both the legs have been fractured, and what is you also obtain the condition of the victim. The condition of the injured victim.
Your lordship, may see मोर स्त्री गोटे एफआईआर देइथला बेली मो ना पूरा हेछि एथरे आ किछि कथा नै सेटा भी मो अनेक्स करछि.
Sir, सेटा कहबे ठीक अछि, but at least you have been named that you have broken the legs with a hammer.
Yeah, seizure is different. Also, one lathi and one bhujali.
Sir, seizure is, sir, even corpus delicti is not recovered. In some cases, still there is a conviction for 302.
Lordship,
so please understand what you are saying.
Though you weapons,
the seizure is not always relevant. Suppose you throw or melt the hammer, it is burnt. So please be conscious of what you are saying.
So, Lordship, only my concern.
So let them get. So you are not helping. So you are not helping the proceeding or the. Yes. How much time you will require?
My lord, about a week.
6 time. List on.
Next week, Lordship.
14/11/2023. The up-to-date condition, the up-to-date instructions regarding the condition of the victims shall also be obtained. Injured victims shall also be obtained.
Lordship, any shorter date, your Lordship. I am 4 months custody. I am twice.
Sir, this is not the only crime committed.
Yes, Lord,
when you make that prayer, there are so many crimes committed. That is, there are so many petitions. I can compel them. That magic will happen.
I have no antecedent at all. I have.
Sir, you could have filed that affidavit, as I told you.
Yeah,
you opted not to file that affidavit. You could have.
No,
court is not begging you to file an affidavit. You must know how to expedite the matter. At least file that affidavit and serve a copy.
Your Lordship, there is no order passed. That's why I have not filed.
Don't make oral submissions. Please, you are a lawyer. You can't vouch for your client that you don't have any antecedents. He has to file that affidavit.
Definitely. I will file that.
So why you are going on insisting? I don't understand.
Lordship,
you are a lawyer. You beyond your brief, don't think anything else.
Your Lordship, I am misunderstood.
You could have asked them. You are now right now also. You ask them and file that affidavit. What is there? Are you prevented? Is the petitioner prevented from filing that affidavit? Please appreciate that.
No. I appreciate your Lordship's contention. Your Lordship twice.
Sir, that's so what is my contention, sir? It's a fact. It's not my contention. You are saying that I have no antecedent. Please don't do that. Please don't do that while arguing a matter.
Definitely, I will file the affidavit.
To file that affidavit, that is the standard practice now adopted in this the High Court, in all the court-made benches. That I'm only following.
Definitely, your Lordship.
So you could have. So why you are saying so emphatically? You file that emphatic affidavit, serve a copy, let them take instruction.
Only the problem is that my medicament that twice it was urgent. That's why I am Mr.
It may be urgent, sir. It has been rejected by a valid order. Either you want a rejection, I can reject it today.
Your Lordship,
Only urgency you can show if you want it to be rejected.
To show my bona fideness, I have already filed the injury report, Your Lordship.
So injury report shows that there is a fracture.
Yes, Your Lordship.
Both so it is absolutely in sync with the allegation.
Yes, as Your Lordship, please.
Prashanta Baroda has broken 2 legs of a person with a hammer or a bujali.
To 8%, total 8% vote. I am inside custody.
That Prashanta Baroda has been specifically stated in the statement.
Yes, Your Lordship. That
So I'll record and reject it. If you want that, I can do that. No problem. If you want a rejection order, you should have so from the beginning you should have said that, sir. I don't mind if it is rejected on basis of the material on record.
No, Your Lordship.
So please be concerned about the petitioner also.
It is only my endeavor to please Your Lordship.
No, you need not please me. So it is my duty. It's my duty to take up the matter.
As Your Lordship, please.
Update. Is there any criminal antecedents? Yes.
And the health condition also, Your Lordship.
Sir, I have already, it has not to be dictated twice. Instruction regarding condition of the injured victim.
Yes, beg apology.
Or you want anything else? Health condition of
No, Your Lordship. I'm begging apology. And much obliged, Your Lordship.
Yes, please. Next.
32.
My lord, on behalf of Yugal Kishore Panda, permitted to withdraw.
Your name, sir?
Bhavani Prasad Pradhan. My power is not there.
Sorry, please repeat your name.
Bhavani Prasad Pradhan.
Mr. Bhavani Prasad Pradhan, you file a memo on behalf of the petitioner? You don't have power. How can you file a memo? You get the memo and then mention. I'm passing it over.
Okay.
You have signed that.
No.
Who has signed?
Yugal Kishore Panda.
That you say. There's a memo is being filed. Mr. Bhavani Prasad, Pradhan on behalf of Jugal Kishore Panda for the petitioner, Mr. Devasis Naik, additional government advocate for the state. Though by order dated 2/9, madam, you are appearing for the informant. Who is appearing, or here it is not necessary?
Yes, my lord. I'm from the petitioner.
Both of you are there for the petitioner, or
Yes, ma'am.
yes, affidavit dated so and so
1/11/2000.
1/11/2023 today, which shall be taken on record. Copy of the affidavit shall be served on the learned standing counsel.
I have already served.
Shall be served. Who shall obtain instruction? Today is 9th.
City and health condition, I'll take.
Yes. If it is the what you are, so if I've understood correctly, that the same incident No. Olga. It's a council cell, the state council cell. Then your instruction is not correct. Submission is not correct. The London State Council shall obtain up-to-date instruction, case diary, as well as health condition of the injured victims.
Gunshot injury, I'll take.
Yes.
37.
List on
No.
9 or 13 ratio.
9th.
13 ratio. 13/11.
9th.
9/11 avoid karantu. Yes.
37.
My lord, last occasion, let's you direct to produce the surrender certificate, my lord. I have produced the surrender.
Mr. S.K. Patnaik for the petitioner, Mr. Standing Counsel for the state. The Learned Counsel for the petitioner submits that after you surrendered before the Metropolitan Magistrate at Kolkata, what happened? Transit remand
Released on bail.
surrender certificate जोटा कहिले
Interim bail ଦେଇଥିଲେ surrender ପାଇଁ.
so सेठी बेल रे आसले तापर एठी सरेंडर एठी कोठी अरेस्ट हेतिले आपण ओडिसा रे
बरमपुर
सेठी सरेंडर कले कि सेटा देबे ना
सेक्टर सर्टिफिकेट ହିଁ ଦେଇଛି
ମୁଁ ପାଉନି କାଇଁ
ଆପଣ ଯୋଉଟା सर्टिफाइड कॉपीटा ସେଇଟା कलकत्ता ର
ଆପଣ बुझ पार नांती आपण एबीएल एपीएल रे जो अरेस्टेड हेचंती कोठी अछंती
सीजेम बरमपुर रे थिलु
हां
तापर जाई कलकत्ता रे सरेंडर
हेले सेठी आसिले तापर बर्तन बाहर आपण अछंती
हां
आपण सेटा कोठी रे को कंडीशन एटा आपण बाहर सरेंडर केमती करनांती त बुझी पार नांती
एठी तो से बेल देले इंटरिम बेल छड़ले
केचुंदी बाटी दो ना 4 weeks before the learned court in session of the matter आपण कोथरे देखबी नांती कोथ में ठीक ओडिसा रे काहे कि गंजाम रे आपण काहे थिले अछंती मन पिटिशनर काहे कि अछंती
फॉरेन वारंट रे अरेस्ट हेतले
मने आपण को एठी किसी केस पेंडिंग नहीं
नो
सेटा केते सब लागिला आपण कहया पे
He was arrested, my lord, for execution of the warrant of arrest issued by the Metropolitan Magistrate, Calcutta, my lord. For appearing before the learned Metropolitan Magistrate, he was given 4 weeks interim bail, my lord. Thereafter, he surrendered in the Calcutta, my lord, Metropolitan Magistrate and got the bail order there, my lord. And then, my lord, thereafter, he has to surrender in the court here also. After expire of the...
आपण surrender करी कि सेटा मूव करथिले ही थांदा आपण आउ कोडे गलेडी आपण से बोदे फेरी नांती बोदे
since it is the interim bail he has to surrender
obviously that order is very clear paragraph 3 is very clear that he has to surrender पण सेटा surrender करी कि मूव करी थांदे you have created a problem actually कोन लिखले could a learned court in session of the matter that is district that is the learned says the sessions judge Ganjam Barampur in the matter arising out of CS number 43391 of 2023 into bracket part file on the file of CJM Ganjam Barampur देखिए लिखिए पेज 10 रे अछि पण ए जो मैटर रे जोटा पार्ट फाइल है कि सीजेएम रे फॉरवर्ड को अपन सेशंस को जाइचंती सेठी अपन मूव करले से अपन को अलाउ करलेनी देन यू मूव द हाई कोर्ट अलाउड यू इंटरिम बेल टू सरेंडर यू हैव गॉट दैट देन यू शुड हैव मे बी आई डोंट नो वेदर यू आर अवेयर ऑफ दैट और नॉट अपन भावचंद यूजुअल कोर्ट से ताको इंटरिम बेल
मिलला कलकत्ता कोर्ट रे सरेंडर
पारा 3 देखिले
माइलर
कोडी अपन सेटा पारा 2 रे अपन को रीजन लिखाला जे अपन सरेंडर करिवे
एटा कोर्ट रो कोटिंग ता लिखा है ए कोर्ट रो कोटिंग ता लिखा है
पारा 3 you have to surrender then you could have moved for bail actually and if the matter would have been disposed of today
yes
how much time you will take Mr. Patnaik
next week
अपन को सरेंडर करी कि आनी परिवे
I have already surrendered in the Calcutta court.
भगवान अरे आपणकर गोटे जिंस बुझु नांती जे आपण अरेस्ट हेचंती ओडिसा रे इन सीएस नंबर 4339 ऑफ 2023 पार्ट 5 दैट इज नॉट ओडिसा रे जुरिडिक्शन ही नहीं अरेस्ट हबार आगे यस
may I assist him, my lord?
no he is a seasoned counsel but somehow he is thinking that he was granted bail by this court for preventing him arrested in Kolkata. That is not the case.
Actually, what I understood, my lord, foreign warrant has been issued.
Yes,
by the Calcutta court. He was arrested in Ganjam, produced before the concerned court at Ganjam, CJM. The bail petition was rejected there.
Yes.
he came up against the rejection of that bail order before this honorable court. This honorable court granted 4 weeks interim bail for the purpose of
Sir, mate
enabling
bujhantuni,
him to
sir.
appear him before Calcutta.
Para 3 order is very clear that he has to surrender after the period is over. He has not surrendered.
He need not have to surrender now.
No. That I cannot modify.
Because since the Calcutta court has already released him on bail.
Then you see the rejection order. Then you see the rejection order and order the paragraph 3 of the order. He should have surrendered and moved for bail there. City.
Ithi nahi, Calcutta re karibo na.
On କହିବେ ଆଜ୍ଞା ଆପଣ ଆରେଷ୍ଟ ହେଲେ ଏଠି କାଲକାଟା କହୁଛନ୍ତି this court cannot exercise jurisdiction over Calcutta. He should have after surrendering he should have moved the sessions court here that I already have surrendered as per the High Court direction and I may be granted bail. There is a possibility that sessions court would have rejected, that's another thing, or accepted. But ଆପଣ ତ move ହି କଲେନି sessions court ରେ ଆପଣଙ୍କର ଯୋଉ court ଆପଣ reject କଲେ ବୋଲି ଏଠିକି ଆସିଲେ ଆପଣ ତ move କରିଛନ୍ତି surrender ପରେ. Then you are presuming as if the High Court is the executing court of warrant. Warrant को court execute କରୁଥିଲା? Obviously. CJM କେମିତି ଜାଣିବେ ଆପଣ ସେଠି ଯାଇକି bail ରେ ଆସିଲେ ବୋଲି? That is how the paragraph 3 has been very specific. You should have same day you should have moved for bail that already you have been granted bail. So the warrant has been satisfied. The petitioner shall have liberty to move the learned court in session of the matter at that is CJM Ganjam Berhampur oblique the session judge Ganjam Berhampur in terms of the paragraph 3 of the order granting bail. Jaldi hele mate kahibe in terms of the order paragraph granting interim order granting interim bail. As the Chief Judicial Magistrate, seta co-court seta?
Metropolitan rejection order.
The Metropolitan Magistrate 13th has granted bail as per the copy of the order of certified copy. Copy of the certified copy of the order. Yes. Next week रे रखन से कौन करिए लिस्ट 10-11 आपण इमीडिएटली मूव करि नांती आपण भाबिले हेई गला आसी हाई कोर्ट रे पहुंचले पैराग्राफ 3 टा इग्नोर कर देले आई कांट मॉडिफाई द पैराग्राफ 3 and there is a purpose. If since I am not having jurisdiction, this court is not having jurisdiction, how this court will ensure that you are appearing there?
Yes, I have 20 minutes.
How the High Court cannot even ensure, much less the CJM or the Sessions Court. They cannot ensure your appearance in Metropolitan 13 Metropolitan Court, Kolkata. If it is a Supreme Court order, then that's different thing. Because Supreme Court, you can very well say that yes, I have submitted and surrendered. Yes. Okay. Rest of the matters after recess. over thila.
ନାଇଁ ସାର୍
For 2 PM କିଛି ନାହିଁ ତ?
ନାଇଁ
Call the list.
item 37
beg your pardon, Lordship. Passover item 19, my lord.
19 call ହେଇଯାଇଛି. କଣ ହେଇଛି order କଣ? Adverse order ତ କିଛି ହେଇନଥିବ?
ନାଇଁ ସାର୍ କିଛି
Pray for short adjournment
ମିସେସ୍ ନନ୍ଦ
and take instructions on that.
Yes, that order has been passed as Mr. Acharya was seeking. So he instructed learned colleague Miss Nanda. So she mentioned, and I think for production of surrender certificate or something
Yes,
like
yes,
that.
my lord.
Order has been passed. Date kebe hichi ki?
ହେଇଛି ଏକା
23/11 you obtain instruction.
Yes, ma'am.
Yes, inform Mr. Acharya. Yes.
37
ଗଲା ପରେ
37 ହିଁ ଚାଲିଥିଲା.
38
my lord, may I pray for some time, my lord?
Yes.
My learned friend is appearing. It is a money transaction between two of them.
Okay. That is better actually. You decide what
Let it be
best can be done by
yes.
to seek indulgence.
Yes.
Mr. Mishra for the petitioner. So Mr. for the petitioner, Mr. Standing Counsel for the state, Mr. Amitabh Tripathi for the informant. The learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions. When do you want? As prayed for list.
First week of December.
Yes.
4/12
Obliged.
Yes.
39
In 39, my lord.
Yes. Mr. A. Mishra for the petitioner,
last
Mr. Standing Counsel for the
This honorable court has directed me to file a comprehensive affidavit with regard to the antecedents.
Yes.
I have instructed my client, my lord. His father has to come and swear an affidavit. Lordship may keep it to another date, so the affidavit will be.
A. Mr. for the petitioner, Mr. Standing Counsel for the state, learned counsel for the petitioner. Here you have power. Your name is there.
Yes.
The learned counsel referring to the order dated 11/10/2023 submits that the affidavit in compliance of the order is to has not been filed and some further accommodation may be granted.
Next week, what a date?
As prayed for.
Next week, what a date?
No, you have to serve copy. Yeah, they have to obtain instructions. As prayed for.
It is written in the rejection order with regard to the antecedents.
Could be. List on 14/11. Let the affidavit be filed by 8 or 7. How much time you will require?
By 8th.
By 8/11/2023, copy be served to enable the state council to obtain instructions.
Well,
yes.
14/11.
14.
Well.
For 1 week after.
Mr. M.S.Sahoo for the petitioner, Mr. Standing Counsel for the state. CD and 164 statement is
164 statement is there. 164 statement medical examination report is there.
Submitted by the learned counsel for the petitioner seeks accommodation to advance arguments as prayed for list on
16/11
or further time you want. 16/11/2023. The learned standing counsel submits that he has received the case diary and he has received the case diary.
161 statement and medical exemption, but since it was not there and telephonically I've got it, 161 statement and then medical exemption.
He submits that he has received the case diary. The learned standing counsel shall also obtain the copy of the 164 statement of the victim, if any.
164 statement and medical exemption report I have got.
There?
Yes.
He has received the 166, the statement of the victim recorded under section 164 of the CRPC and the medical examination report. He shall also obtain the up-to-date CD by the next date. Yes.
41.
My lords, learned senior Mr. Kara requested for a Passover because he's held up in his fixed matter for 2 o'clock.
Yes.
So
as far as passing over is concerned, here 4-5 times Passover is granted.
So he has requested.
So since you have now left us, so that is not a problem. But I want a summary of your
filing up my lord's written note of submission.
No, written note I will not help. Because
very
it is
brief, very brief of the case laws and the factual aspect.
So here what
my lords. Additional affidavit and the written note that I am filing, my lords. I'm serving a copy.
And your lordships would kindly pardon me.
Yes, please.
Today I've given a order, my lords, of Gagandeep Singh.
Yes.
In this particular case, section 69, which is the power to arrest, and 70, which is the power to summons. The constitutional validity of this particular provision has been challenged and pending before this Honorable Supreme Court in an Article 32 petition. There, my lord, the lordships have taken this into note, and they have said that in the meantime, no coercive steps would be taken. So this particular gentleman, my lord, moved the Supreme Court in a 32 application. And in that 32 application, he was given an order, interim order of no coercive action. This is one of the cases, and I have found out 3 or 4 cases which have been tagged to this case also. So, my lord, the concept of an arrest or concept of summoning a particular person under section 69 or 70 of the CGST Act is still a debatable issue, my lords. Whether that power itself is there with the authorities.
No, you must have marked that decision by the Honorable Supreme Court recently that if something is referred to the constitutional bench, but it will be presumed to be valid.
No.
And the High Court has to go by the.
Why I say so, my lord? The bench of the Honorable Supreme Court, realizing the gravity of the situation, has passed an interim order of no coercive action to be taken during the pendency. Your lordship would see, my lord. In the meanwhile, issue notice.
Your case is that Gagandeep Singh is also relating to this particular section.
Gagandeep Singh is a power of arrest and power to issue summons. Section 69, which is the main
CGST Act.
Of the CGST or the GST Act.
GST Act, yes, GST Act.
Section 69 is the power to arrest.
Yes.
70 is the power to summons.
Yes.
So these two provisions have constitutional validity of these two provisions in Gagandeep Singh has been challenged, my lords, in an Article 32 application. My lords.
Yes.
In that particular application, my lord, an order of no coercive steps to be taken against the petitioner has been passed, and it has been tagged to other criminal cases which have been pending, WP criminal cases which are pending. My lords. So, my lord, the entire situation, my lord, is now in a state of flux. And if your lordship would see, the other decision of the Honorable Supreme Court, which weighed with that, my lord, it's a recent decision of the 5th of December 2022.
Yes.
Which, fortunately, my learned friend was also one of the parties, one of the petitioners in that case. I'll just place, my lord, the placitum portion, my lord.
That is Vikas Bajoria.
Ratnambar Kaushik versus Union of India.
That was Ratnambar Kaushik.
Yes, Ratnambar Kaushik. Lordship got the second one.
Yes, Ratnambar Kaushik. Yes.
Your lordship may see. Bail. I'll just place the placitum. I'll not bother your lordship with the entire decision.
Yes.
Tax evasion. Allegation against the appellant accused for evasion of GST to the amount of rupees so and so by trading unmanufactured tobacco through non-existent firms for the purpose of clandestine manufacture and removal of zabda. Charge sheet against the petitioner who was in custody for the past 4 months has already been filed. Since the completion of trial was going on for take some time, and also the case was based on documentary evidence, meaning thereby that there was no apprehension of tampering or intimidating or influencing any witnesses, appellant was to be granted bail subject to the condition of surrender of passport and other conditions as might be imposed by the trial court, as has been rightly observed by your lordships. For ensuring his presence during trial. The sections involved, my lord, again, section 132 of the CGST Act, Rajasthan Goods and Service Tax Act. And if your lordship would permit me, my lord, I'll just place paragraph 5 to 7.
3 and 4. We mark paragraph 3 and 4.
No, paragraph 3.
They distinguish actually your case looking at paragraph, because paragraph 3 and 4 are the facts of that case.
No, facts of that case.
So transport of tobacco clandestinely from one place to another.
The allegation, lord.
That's the allegation. So here the allegation is not that.
No, that is transport of tobacco for clandestine manufacture of tobacco.
Yes.
And evasion of tobacco.
Evasion of GST.
Evasion of GST. And I was only trying to point out, lord, that this is an allegation under 132 of the CGST Act. There, in those cases also, your lordship may kindly see.
Yes.
Paragraph 5 notes. Though the allegations and counter allegations are made at this stage, it would not be necessary for us to advert to the details of the rival contentions, since the matter in any event is at large before the trial court.
Just take para 5. Para 5.
No, para 5, I'm placing para 5.
Para 5, it is no doubt true that.
Oh, it is. Sorry.
However, for the limited, yes.
However, for the limited purpose of answering the prayer for grant of bail, the contentions are taken note of. It is no doubt true that an allegation is made with regard to the transportation of unmanufactured tobacco, and it is alleged that such procurement of unmanufactured tobacco is for clandestine manufacture and supply of zarda without payment of leviable duties and taxes. Though it is further contended that in the process of investigation, the transportation of a larger quantity of unmanufactured tobacco weighing about so and so is detected, these are all matters to be established based on evidence in the trial. In considering the application for bail, it is noted that the petitioner was arrested on 21/7/2022, and while in custody, the investigation has been completed and the charge sheet has been filed. Even if it is taken note that the alleged evasion of tax by the petitioner is to the extent as provided under section 132(1)(li), the punishment provided is imprisonment, which may extend to 5 years and fines. The petitioner has already undergone incarceration for more than 4 months, and completion of trial in any event would take some time. Needless to mention that the petitioner, if released on bail, is required to adhere to the conditions to be imposed and diligently participate in the trial. Further, in a case of the present nature, the evidence is to be tendered by the respondent would essentially be documentary and electronic. The ocular evidence will be through official witnesses, due to which there can be no apprehension of tampering, intimidating, or influencing. Therefore, keeping all these aspects in perspective, in the facts and circumstances of the present case, we find it proper to grant the prayer made by the petitioner. Hence, it is directed that the petitioner be released on bail, subject to the conditions to be imposed by the trial court, which, among others, shall also include the condition to direct the petitioner to deposit his passport. Further, such other conditions shall also be imposed by the trial court to secure the presence of the petitioner to diligently participate in the trial. It is further directed that the petitioner be produced before the trial court forthwith to ensure compliance of this order. And this particular case has been consistently followed, my lord, by the Honorable High Court of Rajasthan, my lords. I've given that at page 5 of your lordship's of that compilation, my lords.
Yes.
Then again by Chhattisgarh High Court also, which is at page 8 of the compilation. And thereafter, my lords, at page 11, again of Rajasthan High Court, Gagan Kakkar. And this particular Gagan Kakkar, if my memory serves me right, my lord, is also before this Supreme Court, again, along with Gagandip Singh.
Okay.
If my memory serves me correct, my lord.
Yes.
So all these cases, my lord, as your lordships have said, my lord, and these are all documented materials which have been used or which will be used during trial, my lords.
Yes.
So my question of my participating in the investigation, question of my answering yes or no, is just a formality, my lords. Witnesses are official witnesses.
And you are ready to cooperate.
I'm ready to cooperate. I'm ready to cooperate. And in today's, my lord, note, what they have annexed? They have annexed a photograph of mine going to the bank. They've assessed certain documents. And I can't tamper with the documents there, my lord. Nor can I tamper and nor can I say that this is not my photograph. So if they have to establish anything against me, it's already documented, my lords. And the witnesses are all official witnesses. And it's all in the electronic form, my lords.
Yes.
And the IT Act, my lord, gives them the liberty of utilizing all these evidences against me, my lord, subject to further deliberation on that, my lord. So my humble contention, my lord, if custodial interrogation is not necessary, my lords, is it, my lord, proper, I'm asking this humble question to myself, my lord, to detain a person just because some investigation is going on, my lords? Your lordship must view it from another angle, my lords. You file a charge sheet within 60 days, thereby denying my right under 167(2). Then when I file a regular application under 439, the prosecution comes forward and says the investigation is still on and there's no outer limit to it. So, my lord, in all these circumstances, when I'm ready to cooperate, I'm ready to abide by any conditions imposed by this court or by the Honorable Trial Court, my lords. There's no reason, my lord, why the petitioner's liberty at this pre-trial stage should be denied, my lords.
Yes.
And ultimately, my lord, ultimately, at the worst, if they prove it to the hilt, it may be 6 months, it may be 1 year, or maximum 5 years. Because those allegations which have been made, my lord, one is punishable for maximum punishment for 6 months, one for 1 year, one for 5 years. So 5 years is the highest ceiling.
Yes.
And for what purpose, my lord? I'm asking this question to myself. What purpose would be solved, and what purpose would be solved so far as the prosecution is concerned for further keeping me behind bars?
Yes.
And the CGST Act, my lord, nowhere says that if you are arrested, this will be the minimum sentence which you have to go through before your bail application is considered and granted. There's no such limitation.
No.
And in
definitely, pre-trial incarceration has no relation to with but kind of a thumb rule.
That's a thumb rule. No,
that the court is observing while granting bail that substantial period of incarceration has to be. In your case, you are in custody since?
I have been arrested.
10 July, my lord. 10 July 2023.
10 July.
11 July. Yeah. 11 July 2023.
Yes.
And the Honorable Supreme Court was considering a case where the person was only for 4 months and the charge sheet was filed. Your Lordship would see, my lords, the Honorable Supreme Court tab and again says 167(2) is a limb of Article 21. Here I am denied of that right because the charge sheet has already been filed within 60 days. More than 10 years, I think.
Okay.
If your Lordship would kindly... Paragraph 22 at page 136.
Yes.
Your Lordship got it?
Just yes, just a second.
The first compilation which I had given, Lord. This is the second compilation.
Paragraph
22 at page 136. There's a running page.
Yes.
Your Lordship got it, Lord?
Yes.
The jurisdiction to grant bail has to be exercised on the basis of the well-established principles having regard to the facts and circumstances of each case. The following factors are to be taken into consideration while considering an application for bail: the nature of the accusation and the severity of the punishment, your Lordship may kindly note, in the case of conviction, and the nature of materials relied upon by the prosecution. 2, reasonable apprehension of tampering with the witnesses or apprehension to threat to the complainant or the witnesses. 3, reasonable possibility of securing the presence of the accused at the time of trial or likelihood of his abscondence. 4, character, behavior, and standing of the accused and the circumstances which are peculiar to the accused. 5, larger interest of the public or the state and similar consideration. White Prahalad Singh Bhati, so-and-so, so-and-so, so-and-so. There's no hard and fast rule regarding grant or refusal to grant bail. Each case has to be considered on the facts and circumstances of each case on its own merits. The discretion of the court has to be exercised judicially and not in an arbitrary manner. At this stage itself, it is necessary for us to indicate that we are unable to accept the contention of the learned Solicitor General of the flight risk of economic offenders should be looked at as a national phenomenon and be dealt with in that manner merely because certain other offenders have flown out of the country. The same cannot, in our view, be put in a straitjacket formula so as to deny bail to the one who is before the court due to the conduct of the other offenders, if the person under consideration is otherwise entitled to bail on the merits of his own case. Hence, in our view, other considerations, including as to flight risk, is to be made on individual basis, being uninfluenced by the unconnected cases, more so when the personal liberty is involved. Then a Lordship would see they have also dealt with how these flight risks can be taken care of. At page 26, paragraph 26 at page 139. Lordship?
Yes, 139,
running page
Yes.
139, paragraph 26.
Yes.
As discussed earlier, insofar as the flight risk and tampering with evidence are concerned, the High Court has held in favor of the appellant by holding that the appellant is not a flight risk.
I think they're not arguing flight risk.
No, they are saying that fleeing from justice.
Yes.
Since I have a passport, in the
actually, I don't know whether that submission, that flight risk.
Your Lordship, leave it
because some other.
No, Your Lordship.
Some others were allowed to flee away.
No, what I'm trying to say at the highest, Lord,
Yes.
Lord, tampering of evidence is out in my humble submission. Influencing witnesses is not possible because they are official witnesses. And the maximum sentence is 5 years. So that is the severity of the allegations taken into consideration. It will be maximum 5 years. So the other one is ensuring that I appear before the trial court or I appear before the prosecuting agency. That can be ensured and conditions that can be laid down. And if at all they say that I'll be fleeing from the country, there also the Honorable Supreme Court has said that you are free to have a lookout notice, impound the passport, and therefore, Lord, there's no other, you're putting very stringent conditions on the individual, Lord. And these are all pre-trial, investigations and pre-trial incarceration, my lords, in my humble submission, should be viewed much more leniently, my lord, because I'm still to face a trial. And as I've already put it, my lord, I'll again reiterate, my lord, the maximum punishment is 5 years, and the other allegation now 6 months and 1 year. So I may fall within the bracket of 6 months, I may fall within the bracket of 1 year, or at the most 5 years. And I'm willing and ready to cooperate with the investigation.
Yes.
And I've given, I'll not waste your lordship's time. The Honorable Court's judgment, my lord, where they have considered Jagan Reddy, my lord, page 5, my lord, the first judgment.
Page 5 of which?
Page 5, my lord, of the compilation. First compilation, my lord.
That is Gurdit Dang.
No, that is M.S.Sahoo was the state of Orissa.
Okay. Yes.
Your lordship got it?
Yes.
At page 5, they have considered Jagan Reddy, my lord. They have followed Chidambaram's case, my lord, at paragraph 8. And then, my lords, they have laid down conditions and they have allowed, my lord, at page 9, running page 9, paragraph 10.
Yes.
In the given case, just please.
Yes.
Here the allegation was almost same, Lord, 132 1BC and I of the OGST Act. The maximum punishment prescribed under.
Yes.
The maximum punishment prescribed under this imprisonment for a term of 5 years with fine in the case of the amount of.
This has been upheld by the Supreme Court or not been challenged?
It's not been challenged. All these compilations, in my humble submission, was never challenged before the Honorable Supreme Court. It was accepted. And I've given, excluding Lord Chidambaram's case, I've given the judgments of this Honorable Court. I've given the
Chidambaram, the bail bond was 10 lakhs.
I have to check up.
I just, in fact, we can look at that, but here it is 35 lakhs.
I have to check up. The bail bond was amount to
last
1 lakh. 1 lakh.
1 lakh, exactly.
1 lakh,
not 10 even.
Page 33.
33,
page
internal page 26.
Yeah, at 145, page 140.
And Shruti Ranjan is 35 lakhs.
35 lakhs.
Yes.
So I prepared for Lordship's convenience a tabular chart of the judgments given by Learned Senior.
Yes.
Where all the bail conditions have reproduced in one chart. I'll hand it over to Lordship so that Lordship can see what conditions. But Lordship, conditions will discuss after.
No. Definitely. I mean, don't be anxious that.
Because once, my lord, once I make out a case where your Lordship would consider granting bail to me, my lord, then the conditions would come.
To be fair, Mr. Mahapatra, till now the argument is that whatever is the case that has been made out by the prosecution, he's not going anywhere else other than sticking to the allegations made by the prosecution in the case. Maybe the citations he is giving, obviously, it will vary from case to case. There are several allegations in so many cases, so that those. But in your case, his entire submission is confined to the allegations you have made.
I am grateful that he's admitted to his offense. He says I'm involved, but because incarceration.
I don't say that's what I don't say I'm involved. I'm sorry, my lord.
Because he says photography is there.
I'm sorry.
I am standing there. I'm giving cash.
I beg your pardon.
What I understood, my lord.
I beg your pardon, my lords. I say, my lord. What I say, my lord, is you have taken my photograph. I can't tamper with that.
He says the other way around. That if somebody produces my photograph, you can't say that. You can prove my complicity by simply producing a photograph. But anyway, that's not the matter to be argued here.
111 entities.
Yes, please continue. Please continue. Yes.
There's 111 entities which have already been identified. I can't, Lord, I can only say deny my involvement in those. And all that.
In your case is that even if 111 or more than 111 are identified, me tampering with those evidence is not possible.
I cannot, no, it's impossible.
That is what I was telling him. Whatever you have discovered by the investigation is relying on that.
And if this 111 is again multiplied to nth time also. Maximum punishment is 5 years, my lords. And I am facing the same prosecution. Maybe the amount is supposing 2.5 crores, it may go up to 250 crores or more than that. Beyond that, it can't be done, my lords. And your lordship would be astonished to see most of those companies are active companies. The list which today my learned friend has given, my lord, if your lordship would appreciate, most of them are active companies. So at least that is one of the difference which I have, my lord, to say that I am not in any way connected. They are active companies, independent entities having GSTN numbers, my lord. It's not that I have played fraud for all these 111 companies.
Assuming that ultimately they are able to prove that.
My lords. And your lordship would see on their own showing, my lords, on their own showing, if your lordship would kindly see that today's additional affidavit, my lords. Annexure.
Let him respond, then you can respond to the additional affidavit. Because right now I am not taking up his affidavit. And let him respond to your submissions.
At page 13, if your lordship would see, just
1-3 or 3-0?
1-3 of their additional.
6 is the photograph.
6 is the photograph. That is what I'm.
This photograph everyone is having. Did you mark? This is a photograph of the CCTV camera inside the ATM.
Malak.
Which one of us who are sitting in the this court is not having this kind of a photograph?
If we enter this Hon'Ble court, we are having a photograph.
No, this is the ATM photograph, I think.
Malak.
So anyway.
If your lordship would kindly turn to annexure A by 9. Sorry,
yes.
A by 12.
Yes.
These companies, my lord, number one, company status is active. It continues till 7.
You are referring to which page?
Page 13, 1-3.
1-3, yes.
Your lordship would see the status of the GSTN. Active, 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 active. Then cancel. Then again 14 active. Your lordship got it, Lords?
Yes. Mr. Kaura, that this question, if I remember, I asked you. Just because since we are almost completing the hearing today. So I was asking you, what is your response to that? That is my proposition, that how to ensure that you comply, you don't indulge in any kind of activity according to, because you see.
But I'm in business.
Because that is how I was giving you. That is how I was giving you that example. That in almost all cases, it is said that he's a law-abiding citizen and he has been implicated in so many cases. After being arrested in one case, he has been remanded in 15 cases. Assuming that all the cases have been reported, that's the counter question I will ask them. But here, these kind of a situation, these are all hyper technical or you can say highly complicated. So, what is the condition that can be imposed that you are not indulging in these kind of
your lordship would appreciate,
because that condition,
basically, I'm a businessman. I, with my sincere efforts, would try to run my business according to law. Now, sometimes, my lord, they will come up and say that this is not in accordance with law, or you are involved clandestinely in XYZ.
No, a businessman, can he open 100 or 200 companies?
No, he can. But unfortunately, my lord, these are all independent entities. Your lordship would appreciate if GSTN numbers are given, my lord, you can't say that those companies are not traceable. And your own annexure says most of these companies are active companies. So how am I implicated, my lord, in an active company, my lord?
So your contention is that, or your contention is that this is something not prohibited by law.
This is something not prohibited by law to take a registration under.
So they are concerned with something because there is a tax evasion.
Money.
Or these activities utilized as a leeway to evade or avoid tax.
And that allegation, my lord, can be made at any point of time. So if your lordship would put that condition, so far as I am concerned, Lord, that can be, in my very humble submission, Lord, abused by the prosecution at any stage.
No. You see,
because you know they have.
Then I have to rephrase my question. My question is very simple. Day in, day out, this court directs that he shall not indulge in any kind of activity which shall
against the law
or anything. But here what is happening? This being a technical thing, this if you can create, say,
that will be
100 or 200 companies. I'm just giving a hypothetical number. I don't know exact number. So how you can be prevented from creating further 300 companies?
Your Lordship would appreciate. I am not estopped under law to create companies or to run companies.
Fine. So that is how I made a distinction. Yes, the creation of companies or starting a company or registering a company may not be prohibited. But utilizing the means, utilizing that through evade or avoid tax is prohibited.
That, my lord, is prohibited. That again, my lord, is a very subjective term, my lord. What is not evasion of tax for me may be evasion for the department.
Always.
So, my lord, if that particular condition is there, I'll be open to arrest.
No, the problem is that these things have been criminalized now.
No, as
the definition makes it a criminal act. Whereas all aspects of a business may be a violation or evasion of a tax is not criminalized.
No, nowadays.
So this is criminalized since when?
Nowadays, my lord, if the goods are...
This activity is criminalized since when?
No, right from the inception, my lord, 2017.
2017.
And earlier, my lord,
so
central excise.
In 2016,
earlier to that, service tax or central excise had a almost similar provision.
Okay.
So what I was trying to humbly say, my lords, that this will be giving a long rope to the prosecution. You have a remedy under the Act. Now, supposing I commit an offense, you have a remedy under the Act. Now, I can't ensure that what is good for me may be bad for you also in your through your lenses. I would say that I'm supported by law. You'd say you are against the law. So giving that particular condition will be giving them a long rope to get back at me with mere vengeance.
Yes.
It's not a question. It's not a question of a 376 case. It's not a question of kidnapping.
No, they're
not a reformative.
Mr. Kora, actually, you have got that absolutely right. Because when we are imposing a condition in case of a 498A or 395 or whatever offense, there the court is conscious that it is quite noticeable.
And it concerns the individual.
Concerns the individual. But here the allegations are something different.
And unfortunately, two parties are concerned. What is legal for one party may not be legal for the other party. And the other party, my lord, is much more powerful than
the definition of a crime in IPC and the definition of crime in
it's always individual, my lord. It's always individual. An individual committing something against the state or an individual committing something against the person or whatever. So that particular power to amend or restrain will be qua the individual alone. But here, my lord, when two parties are involved, when I'm doing business, my lord, I have to interact with various factors and the prosecution also or the statutory authorities.
Are you stretching to the extent of submitting that whatever you have been doing, you will continue to do that?
No, provided, my lord, it is not legal. Because what I am trying to say,
no, why should you say that?
No,
you at least at this stage,
this condition.
At least at this stage, you are also not sure.
What I'm trying
I mean, the petitioner is also not sure. What
I'm not sure whether
legal.
According to me, I have not committed anything. According to me, it's all in a pre-trial stage. Now, in this stage, if your lordship would at all grant me bail, putting a condition that I'll not be doing this or doing that, my lord, may not be possible for me to carry.
What is the necessity of you not having being fettered in some ways?
Fettered, my lord, I'll your lordship fettered in your lordship would see it's not an individual case. Now, supposing I file my returns. The prosecution says...
No, that is requirement of law.
No, that is... So, if it is a requirement of law, my lords, that there is any...
Your activity as a part of the...
I can only assure you...
As a MD of a company, in accordance with Companies Act, in accordance with, say, Income Tax Act, or some other revenue law, can be prohibited by them. They can't question it.
But unfortunately, supposing today I take a loan. Let's forget about the CGST, my lord. I take a loan. They say that this loan has been availed in the name of fictitious individuals. So even if I'm paying my regular installments to the bank, they say that you have committed a crime because
taking loan in name of fictitious individual is any day a crime because repayment is not a
criteria.
It's not a criteria.
So he is trapped. Whatever he does, Now, supposing he takes his loan himself, he takes it for building a house, he utilizes it for buying a car. That may be controlled because there the individual has a choice that he has to abide.
So there, as Mr. Mahapatra has done, he's saying that then you should have also made a compilation of the conditions. Because for a court adjudicating, it is so easy to impose a condition. Even yesterday, there was a matter, a lady has drawn checks, drawn some amount from the bank, it is about 7 lakhs. Thereafter, she is not explaining. I spent quite some time in explaining that if you have spent it, she says that I spent it bona fidely for the official purpose. She was the drawing and disbursing authority of a government institution. But rest is not disclosing, or the council was not disclosing that what happened to that money.
I am not averse.
So no, you see, then it is so easy.
No,
it is so easy for a court. But here the court is having a difficulty to understand. Because you see, it's not appeal, it's only a bail. You see, it's only a bail, so with an allegation. So exact overt act attributed is somewhat complicated.
Exact overt act is yet to be established.
Could be, yes.
And is yet to be established.
Let me borrow your phrase, is yet to be established. Yes. But the thing is that for a court, how to regulate that?
No, for a court,
because somebody committing 395, it is so easy saying that you don't do it.
But for this particular person, my lord, who is in business, he's always prone, my lord. He's always prone to those allegations.
So you have seen the compilation of conditions. You have provided a copy.
I'll provide my all the cases, his cases compilation.
Yes.
So let my
I mean,
I'll share a soft copy. I am also reading a soft copy.
Let them say, come up with a
No, I'm only giving from his judgments, his compilation.
No, what he has done, because you are also reading those conditions actually. So he has just compiled that part.
My lord, I'm grateful to him. Your lordship may impose those conditions also. And in none of those, they have imposed a condition.
The idea was not of conditions. The idea was to distinguish those cases.
Right. Absolutely.
Those conditions, my lord, in none of those cases, there was a condition.
To start with, he has been saying that there's a long way to travel for him. That stage has not long. Yes, we have already noted.
No, all these cases, my lord, they had a long way to travel.
Yes.
Still, your lordship considered the gravity of the situation and granted bail.
Yes. No, this jurisprudence, in fact, I was reading an article recently, article at the national level, that much I can say.
Your lordship,
that one of the reasons of this courts getting clogged is that nowadays the bail petitions are argued in Supreme Court. Article by an erudite author, at the national level, and this is a genuine concern. And it is also debated in, the legal circle. That much I can say. Beyond that, I can't.
No, your lordship may see those conditions.
Yes.
And let my learned friend respond to my humble.
No, yes, he has done that. I was telling. So since he has done it, so maybe you are not required to explain. He starts with Smriti Ranjan. In fact, that is your side. In fact, you were reading it. You were reading those conditions. Yes. Anything else, Mr. Kora? Yes.
My lord says
you have filed an additional affidavit today, and he has partly responded to that annexure A by 13 that those are active companies. Yes.
Last occasion, Lordships, I had given an overview that how
just raise the microphone.
My lords, how the petitioner, what is the modus that is employing? Yeah, is it? My lords, am I audible now? I'll be louder. I'll try to be louder, my lords. The allegation against the petitioner is that what does the petitioner do, my lords? How we found the petitioner? Petitioner was that photograph my learned senior drew attention of the lordships. That photograph was of the petitioner withdrawing cash. Now, whose cash was he withdrawing? Now that takes us to the genesis of the matter. The genesis of the matter is that petitioner is how he's interacting with all these companies, all these entities. My lords, I have also given.
That was an ATM withdrawal.
ATM withdrawal
by a card.
By a card.
You have verified that.
Verified that.
Okay.
I have also given the statement of the bank of that particular entity, from whose account the money was being withdrawn, and he has nothing to do with that company. And despite doing nothing to do with
how the card was issued, ATM card was issued.
That's I am coming
against which account, which savings bank account.
What the petitioner, the modus that is being employed is that,
or it's a credit card.
He is sourcing he's sourcing the IDs of gullible people, of people of the lowest strata, of laborers, of rickshaw pullers, and he's creating these entities. And by creating these entities, he is registering their GST numbers. Malats, I have prepared another compilation of case laws and.
No, you can
explain
in a flow chart.
Malats, I'll tell you. The modus I have to show because what is happening.
Because by simply
I'll explain.
Opening an identity of a very lowly situated person, maybe a daily wager, will not benefit the petitioner unless something else is received by him.
So what has happened? I'll just show you. What happens is that then GST number, GST registrations are obtained. After obtaining GST registrations, without there being any actual transaction, for GST not being to be a legitimate transaction, there has to be a transaction, and beneath that there has to be a ITC. There should be a trade that this particular invoice should be issued. On the basis of that, the ITC is claimed. Here, without there being an actual transaction.
Just a second. Yes, please carry on.
Well, it's because to be eligible for taking ITC, the requirement is that he should have a tax invoice and there should be a receipt of goods or services. Now, I'm handing over a compilation of relevant provisions and the case laws. I'll draw your attention to section 16. When does a person become eligible to get ITC? Now, there has to be actual transaction and there has to be actual supply of goods and services. Here, it is a case that the petitioner is neither in receipt of tax invoice, neither in possession of tax invoice. Now, let's have page 2. I'll show the conditions.
And Mr. Mahapatra, I mean, I'm not curtailing you, but one thing is that if you could have gathered from Mr. Kora's submissions, actually he's not going there. To that extent, perhaps that prompted you to say that I have done it, but he is not saying that. He's not entering into that area. Whether his activity is legitimate or illegitimate, he's not entering there.
I'll show you, Lordship, how he's coming the dragnet of section 132. I'll satisfy Lordships. So what
he's not, I think he may not be in so many words, or he has not considered. But his point is that this court need not go into whether I have committed the offense or not. This court has to take into note of
that is the
maximum punishment, the standard of investigation, the rules of investigation. This investigating agency has to apply, period of incarceration, and individual liberty.
The condition. What brings us to this offense that has been committed to petitioner? Petitioner without undertaking any actual transaction, petitioner without any actual supply of goods or service, without any invoice. What is happening is petitioner is
taking ICT,
taking ITC. And the ITC is being carried forward.
Input tax credit.
ITC, all these cases, what the reason of giving this compilation was all these cases dealt with fake ITCs. Now, this is one fake ITC plus something. What is happening is after getting fake ITC, when these are sometimes known as zero-rated supplies. When they are exported,
so to curb that, what condition is to be imposed?
I'll come.
Allow me to
explain the transaction.
No, I understand. Because I have anxiety of reaching the end. Because I have anxiety of reaching the end point. Suppose if I'm inclined to grant bail, which I'm yet to make up my mind, but there, like every day it is happening. For a judge, it is happening. So if I'm ultimately reaching that point that where I'm inclined to grant bail, then how to, because I have, in fact, I asked pointedly to Mr. Kora, then I have to put a condition that he cannot operate or open any directly or indirectly any account in name of anything. He cannot claim any ITC.
No.
But your case is that he is claiming this input tax credit by in fake. In the name of a person who is not at all there, he's just utilizing their identity.
Not only that, there is no actual transaction. There is no supply of goods.
No supply.
They verified from the Vahan numbers, the Vahan ID portals, that the vehicles used, there is no actual vehicles. These are all fake Vahan IDs that are.
So your case is that at each step, he has been able to maneuver the method,
the procedure, documents to create a fiction of transaction without there being any actual supply of goods. On the basis of this, he has created this whole network of transactions, whole cluster of companies. And after that, what happens? Because, my lords, the government gives incentives.
Suppose he is convicted tomorrow, assume. Because now you have to answer this. He is convicted tomorrow. 5 years he gets released. How to prevent that? That is I'm asking you.
The law
because the law's ultimate objective is, apart from punishing, perhaps the most significant.
This is at such a nascent stage, this particular investigation and this particular kind of.
No, I'm not talking about investigation. See, I'm assuming
offense might go to another agency.
The problem is that you may portray him to be a Frankenstein, or it is a humongous what you call humongous proportion of what you call malfeasance and all that. Let us assume that he is not granted bail. He incarcerates for 5 years. He completes his tenure pre-trial also. But how to prevent that? That is the short question I'm trying to understand. Get an answer. Putting him. If this is a method available legitimately. According to him, it's a legitimate method. Whatever he has done. So suppose he is ultimately, suppose he faces the rigors of law. He faces trial and he's convicted. Assuming. It's not a question of now bail. We are hearing an appeal now. Let us assume that he has been convicted. Now post conviction he comes for appeal and seeks grant of bail. Obviously, then there will again be a condition that this kind of crime is not repeated by the perpetrator. But the way you are portraying it, that it is impossible to prevent. So that really concerns the court. That unless he is put behind bars, this person, and he's the only person. Your case is that he's the only person who can do it. Unless he is put behind bars, this can be prevented. So that really disturbs the court to get an answer. Not in dances because somebody is incarcerated. But apart from that, this crime has to be prevented. It has to be prevented. Something should be there.
GST is a new legislation, and this problem that is of fake ITC being misused. This is of recent times, my lords. And fake ITC along with zero-rated supplies.
No.
What is the modus?
As far as Orissa is concerned, there has been a committee directed by the division bench. As far as sales tax, VAT.
Sales tax was concerned, VAT was concerned.
Yes.
There was a committee constituted by Honorable Justice B.P. Das, as his Lordship then was.
Yes.
And
I didn't tell the name.
And the Lordships are also at that relevant point of time.
Yes. So, in fact, they have found out suggestions. And they have made suggestions that was placed before the court.
Sitting regularly to set over all these issues. They're trying to for that ease of doing business. They're trying to make it, my lords, the kind of cases that have been cited by Learned Senior in support of grant of bail, my lords. Those cases concern fake ITs, my lords. I'll explain the difference. All cases are factually different. Because when a businessman is doing business with another company who is indulging this fake ITC, I hope I didn't interrupt your flow. Actually, I didn't want to, but since because I thought that I should tell you that actually I am also concerned with the end, because after hearing for say some time or maybe for days together, I have to arrive at a conclusion. Then either way there has to be a concern of the court that how to prevent it. So, my lords, what happens?
Because if ultimately by putting him behind bars, suppose I reject the bail even. Still, I'm unable to prevent the crime because I don't know. I don't know what has happened. But in case of 395, I'm saying that any case of violation of any terms, because I can say that he will not commit any ITC offense. Again, ITC is coming to my mind again and again. ICT, input tax credit, IPC. IPC offense. It is so the predicate offense is so simple that I simply say that he shall not escape the jurisdiction. He shall report to police. But these conditions are also not contemplated here. The reason being, you are saying this is not preventable. Your portrayal of the situation is that almost this can't be prevented even by putting him behind bar. Or the only way is that he's kept inside bar, behind the bar, till the matter is decided finally.
No, my lords, I think I have not made. My lords, the conditions I have to fulfill for denying him bail, my lords, is that first of all, whether he's prima facie involved in the offense. The tripod test he has to satisfy to get bail. Whether he's prima facie involved in the offense.
In which of these cases, this compilation, the first condition has not been satisfied. Everywhere the allegation has been said that this person, you see
I'm coming to second and third.
The court is very conscious of that. Nowhere the court has said that the prosecution has not made a prima facie case regarding involvement of this ABCD, whatever cases.
My lord, so the second, my lord, so if lordships, I will come to second and third aspect regarding the flight risk and the imminent threat to the tampering with the evidence. Here, my lords, the investigation is a very nascent stage. In the reason being, because there is a cluster that has been discovered of 111 entities, and summons are being sent to these proprietors or HUFs of these entities that have been discovered. And summons, what happens is that because these are all fake entities, we have to physically verify whether they're actually conducting business or not. If they're doing actual supply of goods along with the invoices, then it is a legitimate transaction. So here summons are being sent when we are going and physically.
What about service? How to verify?
Service is returning unserved, my lord, because they are on bogus. All bogus addresses have been given for creating those concerns. That is the reason I have also annexed this summons, my lords, in my additional affidavit. So what happens is that this is putting a lot of pressure on the department. Department will have to go and physically verify and check whether there is an actual transaction that is taking place in the premises. All these premises, the first premise that was discovered.
So, Mr. Mahapatra.
This is one step. All these cases that have been cited at bar, those are cases pertaining to fake ITC, my lords, that the judgment of Ratnambar Caustic. In that case, it was a case of a tobacco company, which was in genuine business of tobacco. Here, there is no business at all. Because when we visited the premises of Jasem and Rompathar, these two companies that have come to light, the premises that have been taken by Ronaldo in Bhubaneswar, it was found out there is no such, the landlord said that there is no business taking place from this. That is the prima facie that was found out against him. Subsequently, that became the tipping point, a starting point for us to find out, dig deep into the whole nexus of other companies. And we found out that from each company to other, they're passing on ITC, and then they're doing this through channel to Nepal. They're exporting and they're asking for refunds, and they've been able to successfully get back refunds. So on the basis of no transactions at all, they're getting back refunds.
Have you been able to plug this?
We're plugging, my lord, steps are being taken, my lord.
No, I'm not talking about Ronaldo and who is his. What is his name? I mean not this particular person.
Academically, if I submit, my lord, this is purely a case of PMLA, my lord. This is a purely case of violation of PMLA because it's a case of money laundering. So other agencies might take care, my lord. Today it may not be correct on my part to make that observation.
That is another aspect.
Because there is that.
Because you see, this after receiving the money, whatever he is doing.
So my lord, for that reason,
or the way he channeling it, or the way he channeling it to maybe some tax haven or something.
For that reason, my lord, 132. Lordship, I have 132 the provision for grant of bail. So
you can go in your own way. Don't be disturbed by my interjection because I expressed my anxiety is that because I have to reach a conclusion.
I will address one. So 132, Learned Senior was only referring to 132, 1A, B, C, all the other clauses. I'll first
132 of
GST Act, my lords. If your lordships have it,
That's why I was referring to those three provisions was because those are the find place in the charge sheet itself.
Yes.
Charge sheet or Thilakita. That's why I was trying to.
No, my lords, I'll come to. Lordships,
yes.
So lordships read 132 subsection 1.
Yes.
Whoever commits or causes to commit and retains the benefits arising out of any of the following offences.
Yes.
So he's retaining the benefits, my lords. That's where it comes in, my lords.
Yes.
He's by withdrawing the cash. I'm showing the money trail. He's creating these companies. He's sourcing IDs. He's creating the money. He's creating these entities. These entities are using fake ITC to create further transactions in the cluster. Thereafter, they're exporting without there being any actual supply of goods. And on the basis of these fake exports, they're getting refunds from the government because they are zero trade supplies. Because government doesn't intend to tax exports to make it more viable for a foreign exchange to come in, my lords, and make it more competitive in the foreign market as well. So that is the modus. As far as the other aspect, now what we are doing is these all entities, when we're sending it to them, we're finding out these are all from lower state of the people, daily wagers and rickshaw pullers that we have actually verified. They said that these people don't exist. And Ronaldo has identified the whole modus in his statement. One of the arguments that was raised was Ronaldo has retracted through a prisoner's petition as filed. He's retracted. That also shows that how much of influence he has over Ronaldo. The answer would be, my lords, this is a stage of bail, my lords. We are not looking at the evidentiary value of statements and all that. So prima facie, Ronaldo has also implicated him. And this is before a GST officer. So the presumption under section 136 of the GST Act also comes into play. Therefore, the argument that retraction will negate the whole statement that has been made and negates the role of the petitioner in the offense, that also goes, my lords. So the evidentiary value is not, this is not the stage for evidentiary value. This is for the stage of trial. So this is the second aspect. This is the influence that is having over Ronaldo, who was also complicit in the offense. As far as the other people were summoning, my lords, considering that from the lower strata, the kind of influence he'll be building, the argument, if I've understood correctly, if I can crystallize, is that these are all government officers. These are all government officers or government witnesses are government officers.
Mahapatra, actually, my question was to that only. Actually, the argument is not that. Whatever predicate offense you are alleging, it has already happened.
My lords,
nothing more to happen. Your entire endeavor in opposing his bail is that there is a possibility we are yet to discover. We do not know what has happened.
If this
it is of such humongous proportion, the proportion is so large, we are yet to discover. But whatever it may be, the case is that they have identified, they have alleged the offense that has occurred, and it is just possible that it has occurred. I mean, that is how you said that perhaps he's admitting. No, but the point is that as far as the prayer for bail is concerned, once the offense has happened, the allegation is there, and as per the prosecution case, there is nothing more that can happen. That can happen as far as the offense is concerned.
No more. This is what we found so far.
And that electronic evidence, whatever evidence that has been produced by the investigating agency is entirely within the control of the agency.
Well, this is at a very, I would beg to differ from the senior there. This is as if this whole thing has precipitated. This has not precipitated. This is a very dynamic nature of the offense that has been conducted, and the process of discovery is taking time. This is at a very, very nascent stage, my lords, because unless we summon those particular proprietors of these concerns, these proprietors don't tell us about the borders, how their IDs were being utilized. We might unravel other aspects of the transaction which we today are not in a position to discover. So to say that the whole transaction has happened and the whole issue has precipitated, nothing more to be discovered, the witnesses are government officials, nothing more is left. Witnesses are not government officials. The witnesses are gullible people under the total influence.
Witnesses, as far as this ITC is concerned, because ITC is not granted by those people.
But
they are in their name. Your case is that in the name of a gullible person, a fake ID is created. But I don't know how far you are, how far you are saying this, because you see there is a bank account, there is a valid NTF transaction, and this amount you are saying the amount was credited.
Good scholars. There is no, when we visited the premises.
Prior to that, after getting credited, I am saying till getting the point of input tax credit. Till then, there is a SAM transaction or absolutely no transaction. But after it has happened, still he has been able to get out that money, take out that money.
ITC and
so that part he is saying that it is well established now. Because now by simply keeping him behind bar, the money where it is there, or maybe that after taking your assessment is 235 crores. Your point is that after 235 crores, there is a possibility that it can be 1,000 crores.
It can be, Manoj.
It can be 1,000 crores.
These persons, tomorrow, if he comes out, he has, while being in custody, he has been able to influence the other co-accused who had.
That you should not say. You should have that responsibility. You see the
PAN number. If your lordship looks at the charge sheet of the companies, this PAN number comes out because one person's ID is used for creating several entities. My lords, this is, if you lordship have page 1, my lords.
Yes.
This PAN number. This PAN number is first a state code, then is a PAN number. Then I draw your lordship's attention to the charge sheet.
Yes.
Lordships have the charge sheet. The list starts at page 47. The cluster of fake invoicing fraudulent ITC companies.
This compilation is a convenience compilation.
I'm saying companies, these are actually entities. Some are companies, some are HUF, some are proprietorship concerns. That's what we're discovering, my lords. And mostly
you are referring to 47. Page
47 charge sheet, my lords.
47 of charge sheet, that starts at? Where do you find that?
Charge sheet was submitted by way of memo by the petitioners.
That's a flag B, notes. Flag B is the charge sheet. No, flag B.
That is B for Bombay.
The B for Bombay.
My lords, the precursor to that, my lords, at para 9 is that what is the basis? What is the connection?
But so in this bookmark, there is nothing in the bookmark. Yes, you carry on because
the kind of
my paperless brief has not been bookmarked.
The kind of maze that has been what happens, the difficulty with the department, what happens?
May I just share my copy?
I'll give a copy. Yes.
So what happens is that GST numbers are there. GST number comprises of PAN number, state code. Then there is a registered mobile number. Then there are other IDs. From these details, we are discovering the connection from one entity to another. Hello,
Yes, yes.
Hello, page 46. Why the discovery is taking time? Page 46. Investigation revealed that 28 GSTNs have same mobile number as Galaxy Enterprises, having GSTN such and such, and the purported supplier of M.S.Sahoo Rompathar General Overseas and JASM Overseas, and therefore appear to be a part of the subject fake ITC network.
Sorry, huh?
Lordships have it?
Yes.
Okay, it's 46 minutes.
आपण এটা কেমতি বাহার করলে কেমতি তো ফ্ল্যাগ মার্ক নাই এতরে কিছু yes, 46.
So the investigation.
Para 9.2.
9.1.
9.1.
So GSTINs have the same mobile number as that of M.S.Sahoo Galaxy, having GSTIN such and such, and the purported supplier of M.S.Sahoo Rompathar General and JASM Overseas, and therefore appear to be part of the subject fake ITC network. So the mobile number is one of the IDs mentioned for creating that entity. Then they have the GST numbers. So from the GST number, there is a PAN number. My lords, this then 9.3 is the list of the company, of the entities. I'll show your lordships at page 56. Just two entities I'm showing.
So I'll just intervene, my learned friend. This is all a part of the chart sheet which has already been submitted.
No. I think he's conscious of that.
It's not a trial court to which is being argued, my lord. Evidentiary value, my lord. I'm assuming the worst against me, my lord. I can't go beyond this chart sheet.
Yes.
I can refrain.
No, I think that is not his endeavor.
His endeavor, my lord, he's not repeating.
Perhaps
this is already query. No, this is already submitted.
Efforts are to put words in my mouth, my lords. I request, my lords. I did not interject, my lord. Senior.
No. He's not.
So if this chart sheet is read page by page, my lord, it is already on record before the honorable trial court.
No, that point is well taken. Yes, Mr. Mahapatra.
My lords, page 56. There are 107 to 111. There are 4 entities.
Yes.
My lords, especially 107 and 108, the PAN number is same.
Yes.
110, 111, PAN number is same. Because GST number, this is GST number. From that, lordships, there is a common part, is a PAN number. So this way, we are discovering these entities from using this permutation or combination of PAN numbers, registered mobile numbers. So this is reading like a never-ending maze that is opening up. For that reason, this is taking time. And the moment he comes out, he will stop this because he's not been cooperating behind bars. He's not been cooperating. He's been giving evasive answers.
No. The PAN number of the company is same or the individual is same?
No.
110 and 111.
Common GST numbers. GST number comprises of the PAN number.
No, that PAN is of income tax under income tax or something else.
Income tax.
So that can be same.
Same, my lords.
That can be. I mean, that is nothing unusual.
No. But GST number, a part of the GST number is a PAN number. That's why the page.
Part of the
GST number is a PAN number.
Is the PAN number.
PAN number. That's why. That state code, then the PAN number comes out. GST is based on PAN, my lords. So he's creating this PAN.
So why do you find that?
My lords, may see that, for example, page
110, 111.
110, 111.
There is nothing like that.
My lords, may see the 27. This is same.
Serial number 27, you are saying. Or page 27.
110, 111.
Yes, 27 BHXPY02.
0203.
0203
same. So the same PAN number is again used to create another entity.
Yes. So I think, I mean, does the investigating officer find anything unusual that with same PAN number, two GST numbers are created because there are terrestrial general overseas, one is at Maharashtra and one is at Nagpur.
No, my lords, my endeavor is to show you, lordships, that what happens is that he's using these multiple permutation. For example, he uses one GST number, another registered mobile number. He uses one address and another PAN number. So another GST number. So this way, the whole thing is like a maze for the department. This is taking time. And then we are verifying from the proprietors of these particular GST numbers of these entities that who are actually behind it. And so far it has come out that these are actually not the real people. These are all people who are indulging in low-paying jobs, who are not people who are.
How many people you have found like that till now?
But I have enclosed some of the summons.
No, I am not there. I am not there. Your allegation is that very basically paupers, or you can say very low-paid employees or daily wages.
Kind of transactions.
So they have been operating these accounts. So this is nothing new. Earlier it has happened. But how many people actually in person you have found?
Earlier, my lords, accounts can be operated by someone on their behalf. But accounts being operated to use fake ITCs, then to make exports and to get refunds, this is very new, my lords. Now
I understand that.
This is a very
but till date,
and my lords,
till date, have you found any person? Actual physically you have found any person?
When physically we have verified the premises.
How many you have found? That
premises in Delhi that have been visited as per my instructions. And the neighbors have said that this person is a laborer, this person is a rickshaw puller. They are surprised that how the MTT can be registered in his name. That is the instruction, prima facie instruction that we have got so far. So they've shown, when we have shown the photographs, they said that this person cannot run the. So with the department, I said, why don't you take action? Why don't you arrest these people? He said, what will we find from these people eventually? Because these people are eventually not the kingpin behind the offense. The kingpins of retaining the benefits is the petitioner. Petitioner is operating their accounts and using their accounts in order to get the benefit eventually. That's why that retaining benefit under 132, that was not there in the original act. That was brought in by way of amendment. The scope was widened. Subsequently, with the Finance Act, 2020, it was widened because these kind of offenses came to light. This is also coming out from the GST Council recommendations. I was reading some of them. That initially the provision was narrow to create, but because these GST numbers were being utilized, fake ITCs and these kind of things came to light, this was the whole purpose why this scope was widened. The legislature has widened the scope and ambit. That is for a purpose to tackle such kind of evasion. This is not a case of evasion, my lords. Evasion is a very light term for someone who is running a business and who comes across as while doing business, he comes across
tobacco business.
Comes across a fake ITC company and he is trapped. Then he goes to the court, he asks for refund because he is entitled to a refund because there can't be double taxation. That is the case of genuine ITC. That is the intent of the GST Act. So that is the reason 138, the part is compoundable. But 132, 1A, B, C, the part we have right now before us, that is not compoundable. That has been excluded. They argue, one of the arguments was this is compoundable. If it was compoundable, he should have applied for compounding. Why has he not applied for compounding? Because this is not compoundable in nature. The nature of the transaction is such that it is not compoundable in nature. He is not only violated the provisions of the CGST Act, but IGST provisions also he has misused in order to get that refund of the zero-rated supplies minutes. That is one step ahead. This is not a case of fake. So that's the reason I gave that list of judgments. Those judgments, my lords, pertain to fake ITC and some economic offenses. And my lords, another judgment that is part of my compilation, which I'd like to draw your attention.
Today you have filed it.
That is, my lords, I'll show only one judgment because I'll not like to burden you. That is Nimagata Prasad. That is at page 347 of my compilation. In that judgment, my lords, one important aspect regarding economic offenses was said. Economic offenses not only were grave, that was already said since 1987. One judgment of the Hon'Ble Apex Court has made it clear that the economic offenses has to be treated differently from normal offenses. But Nimagata Prasad says that economic offenses with an angle of conspiracy takes it to a different level altogether. This is a case where he has conspired with all these people and created his maze of transactions. That's why it's one level up from normal fake ITC cases. That is my submission. And that is the reason, my lords, all these cases of Sanjay Dhingra, Himani Munjal, these are subsequent cases that have come. These are of the subsequent, the recent times.
So
that you are referring, that is in your compilation.
Compilation, my lords. I have handed over. Lordships have the. I will deal with each of the contentions that have been made in brief in the written note. So it will make it very short, my lords. If I see lordships page 3 of the written note that has been filed by the petitioner, I'll only respond to that and leave it at that, my lords. I'll just cite the relevant case laws and leave it, my lords, at that. The first contention under para 11A, that the petitioner is not connected to the alleged offences in any manner. Okay. Lordship, I have shown earlier whatever I had filed regarding the statement of the co-accused, where he's explained the whole modus. And we have also used forensic experts to find out materials that he's operating these bank accounts from his phone. He's using 2 mobile phones. He's saying that I am not the owner of the other mobile phone because that is also again registered in some other person's name. He's using one iPhone 14 Pro Max. When we use forensic experts, we found out the location of the phone, blue Redmi phone, and the location of his phone is identical at all times. And he's not cooperating with the investigation. Whatever materials we could locate from the phone by using forensic experts, we have found so far. So he has evidence which we can discover, which once he is released, he can destroy, my lords. So that is one limb of my argument, my lords. Other limb is, my lords, once he comes out, these gullible people we are tracing, who are behind these small proprietorship concerns, which are just paper companies, paper entities being utilized.
No, your problem, because you have candidly answered that you hardly you have got any 3, 4, 10 people.
That is what we found, my lords.
Three persons.
That is what
one apart from Ronaldo.
No, my lords, 3 persons we have gone to when we went to the premises of these premises in Delhi. We found
because you see, for a court now, for a court now to delve into that issue where you are yourself not so sure, it becomes very difficult.
I, my lords, take the up-to-date instruction regarding that. How many there, because summons they are sending, this coming, returning unserved, they are going and verifying from. They have to go verify.
No, that is part of the investigation. You see, you are saying
once he's out, can my lords imagine a situation
to sum up your submission, or maybe one aspect of your submission is that is much easier.
IPC managers the profit.
You see yes. Suppose some PW is not responding to the summon of the court. Can the court arrive at a conclusion, since the PW has not been is not responding? He's influenced by the XYZ accused.
There's a fine line in IPC. The offense has frozen there. Offense has happened. Here, the nature of the offense is such that it's evolving, my lords.
No.
My lords,
you see, that cannot be then there I beg to differ, because also in any case, then you can't say that. You see, you cannot go to, even if a very, very fairly you will submit, you have to support the prosecution case. As a prosecution counsel, you have to support the prosecution case. So that way as a counsel, otherwise, I mean,
can I bring it down to what has been investigated so far? Can I not investigate further? Can the petitioner
exactly
how I have to investigate?
Exactly.
What is the way? Because the argument I understood is that no, they can't do this. Everything has been found. Nothing more is left to be discovered. No. I can't be dictated.
Obviously, but
several judgments of the court that petitioner can't have a say in the way investigation is to be conducted.
Absolutely.
That is totally my prerogative.
Absolutely.
And today, when I'm taking statements, they say everything is done now. Release me on bail because everything is on record and nothing more is left to be discovered.
That is there. That is there. That is there. But that argument, you see, the court has to answer that. The court is in a court has to, because you see, the court doesn't have the liberty or have a choice to go for truth on investigation as far as the court is concerned.
My lords.
Justice Midha's, that is Justice Midha's statement.
My lords, I understand.
Yes, Justice Midha's statement. So that is always there. But obviously, while deciding a bail petition, the court has to go delve into that. The court has to delve into that. And as a prosecution counsel, you have to support the prosecution.
Because, my lords, the day we had initially filed charge sheet, it was 106 entities. Today we have 111. So what do we do about the 5 more that we found? We don't file it. We don't bring it on record.
No. That's not the point. Obviously, Because I told you that even I am not talking in hundreds.
Another contention that was
So because your submission is that there is a possibility of thousands crimes could have been committed.
My lords, in my
We allege 106 crimes. There is a possibility of 1,000 crimes could have been committed. That's your point.
There's one contention raised that there's one contention raised by the petitioner that we have never sought permission to file supplementary charge sheet or further investigation. In our charge sheet itself, at page 81, specifically we mentioned that further investigation is underway to unearth more materials regarding the.
Today he didn't argue that. Today, on the first date, he said that. But today he didn't argue that. Today he didn't say that they have sought for liberty. You have kept it open. Even without looking at the brief, while taking up the matter, my impression would be that you have kept it open. Nowadays, nothing is kept closed, except very few cases. Yes.
So in between also there was one judgment of the Honorable Apex Court, Ritu Sabria, which was regarding that if investigation has not been completed, how could the prosecution submit the charge sheet? Therefore, the accused is entitled to bail. That larger bench has stayed that observation because that was sought to be argued in the last occasion. I verified that the larger bench has stayed that particular observation that just because investigation charge sheet has been submitted without completing investigation, the accused is entitled to bail. That argument, my lord, this will be obviously considered by larger bench. But that argument that because
that is a sound principle.
Again, 173(8) ro jo power ta tankar achi, I have for a moment have not said that is not available to them.
No.
173(8) ta sabu bele achi tankar. So that is a trial chalchi argument I fail to understand.
Yes, please.
It's a mini trial going on.
Yes.
My lord, I am responding to the scene.
Don't get distracted.
Because the argument regarding the evidentiary value of retraction and all that is something to be considered trial, not at this stage.
You see, that is how I said that I cannot make it elaborate here like a Supreme Court judgment where everything is considered because this court has a limitation. Because both of you are conscious that this court, while deciding a 439 petition, cannot go into the merits of the case.
So therefore, the first argument regarding the complicity, I've already demonstrated. I've also shown in the additional affidavit that he was withdrawing the cash, and I've also annexed the statement of the bank, the relevant time where he was withdrawing the cash. That shows that he is the same person, and his identity, as in his CCTV footages from Mayfair Hotel, where the details of the other Rompathar and other companies where he is handling these companies has also been found out. Therefore, my lords, his complicity is writ large in the offence, and these entities are connected with other cluster of companies. Therefore, the offence is of such nature, the gravity which will weigh on the consideration of this honorable court to decide his bail application. Second is with regard to the stage of the investigation. It is investigation underway because we are still discovering, and summons are being sent, and he has substantial control because they belong to gullible sections of society. That is the second condition. Third is regarding the flight risk. He doesn't belong to the state, my lords. He is from outside Orissa, and he admittedly today it was disclosed that he has a passport. And most of the cases that have been mentioned here, my lords, where the bail has also been granted after a substantial period. He's only been behind bars for 3.5 months. And he has not cooperated with the investigation. That the anxiety of the department is because that he has not been cooperating with the investigation. His answers have been evasive, and because of which department is not getting headway, and it is taking time. Using forensic experts takes time, and then we connect dots, and then we find out go to the root of the matter. That, my lords, it takes time. And because he has not been cooperating, therefore, him being in custody is important because he wields substantial influence over the gullible sections who are behind this whole transaction. Therefore, my lords, the nature of the conspiracy of being an economic offense, because it's a conspiracy which is evolving in nature, therefore, this is not the stage where the petition should be granted bail. This is the sum and substance of my submission. And the argument regarding the statement, that is not this is not the stage, the statement of Ronald, because I am protected by the evidentiary value presumption under the GST Act. That same presumption is there under other tax statutes. That's the reason, despite having powers akin to the police, they are not treated as police officers. Therefore, the statements recorded before GST officers have a certain level of presumption. Therefore, the court will give credence at this time of trial. As of now, what the Ronald has implicated him in the entire transaction, that is at Annexure 1 of my counter. That is the reason it is Annexure 1, my lords. Because Ronald has described the entire nature of the transaction, how he has executed the entire thing, and that shows that the petitioner is the mastermind and he is doing this thing. And so in other companies and what is the other entities, what has happened, how they have taken ITC. So for that,
the local sureties and all that, have you filed those affidavits? Because in Because nowadays what is happening here in
No, we can abide to any condition imposed.
not abide, because the tradition in this court now what it has evolved, not tradition as a practice in this court, that in case of outside the persons who are residing outside in many of these
If your lordship would impose such a condition,
NDPS cases.
no, if your lordship would impose such a condition, I'll definitely have local sureties.
No, there has to be. No, because
we can do it.
No, that you see that condition has to be satisfied before the learned court in season of the matter.
We'll do it. I'm open to all conditions which will be imposed by the lower court below in case your lordship decide to grant me bail, and any other condition which will be imposed by your lordship. I'll abide by all conditions.
Yes.
In one of the cases that
no, Mr. Kaura, there is a difference. It will be a precondition kind, because you will be incarcerated till satisfied of the sureties. If at all you are
obliged. Yes. Obliged. I'm ready for that also.
Because
unless your lordship may put a condition.
Because that's a valid point. That's a valid point as far as the interstate crimes are concerned.
Your lordship may,
because passport surrender is a single act. But moving within the national borders.
I'm a citizen, Lord. I'm a citizen of this country.
Moving within the national borders is a different thing.
I'm a citizen of this country.
Absolutely.
It's not that I belong to Orissa or I belong to Bengal. I'm a citizen of this country.
Yes.
And your lordship may put me to terms.
Yes.
Petitioner is claiming superior rights, my lords. He's claiming that he's a more entitled citizen than other people. He's just behind bars for 3.5
understand, my lord.
Please.
Anxiety or the persecution, my lords.
Please wait.
It's unfortunate.
Please wait. If you want to make any rejoinder, also will be allowed. Yes.
My lords, my lords, so therefore, my lords, petitioner has been behind bars for 3.5 months. His complicity is very large. Therefore, right now, the investigation to be completed without any interference. It is important that we require the custody of the petitioner so that we can undertake investigation without any interference. Because the moment he comes out, the influence that he can wield over these gullible witnesses is because it is an admitted fact that he has sourced these IDs, and these IDs have been created of the people belonging to lower strata. The moment he is out, my lords, these people.
Apart from Ronaldo, is there any co-accused? You have named anyone?
There is another co-accused, my lords.
They've not done anything against anyone.
Shane, I would say.
No,
there is another
CA, not even the CA with
the flight risk is also criticized in one of the cases. One of the conditions that was mentioned was the Kashmir Agarwal case, that he should not leave the territory, the precincts of Sundargarh. So, my lords, if
that kind of a condition will be counterproductive for the investigation.
I'm not saying, my lords, if I am talking about conditions, my lords, I assume that lordship is going to grant bail. My lords,
you needn't assume, but the problem is that it's a cyclic process.
I leave it to the conditions.
Whether chicken is fast or the egg is fast, because unless you know the implications of the conditions, there is no point in considering the bail also.
Question of conditions being discussed right now at the stage when we're considering the bail, my lords. First, my lords, let the bail, whether the petition will be granted bail or not, let us be satisfied on that. Because
but then who will address that? When it will be addressed?
Lordship had expressed in the beginning that that's for the court below to actually take.
I understand. But in fact, coincidentally, you produced a decision where Supreme Court has exactly done that. Left it to the court, but some preconditions because
I leave it
because that shows the rather because perhaps then their complaint would be that why the court will be hearing the prosecution till that stage has not come. Because you see, that is a protection for the prosecution. The prosecution is satisfied. The prosecution is satisfied that as far as further investigation, if any, is concerned, or the remaining investigation is concerned, or maybe at the stage of trial, some person is not influenced.
Well, I leave it to lordship.
So obviously, how the court will know that? And these kind of offences, it is very difficult for the court to itself know. Not being the domain expert or either way.
I'll leave it to
like a simple, he will not go out of the Sundargarh and he will visit every day. He will not threaten anyone. Those things are fine. No problem.
No, I'll leave it to lordship wisdom, lordship, whatever.
Yes. Anything else to say, Mr.
Well, this is my submission.
Mr. Kaura, anything?
No, I'll leave it to your lordship. And I'll only say that I abide by all conditions which your lordship would impose or the trial court would impose.
Yes.
In case I'm granted bail.
Yes.
One of the contentions that has been advanced, I had to respond to that because they have said that there is no determination of liability. There can be determination.
So all your contentions are contained in your this written note.
Because
And I only say, Lord, as your lordship have rightly
this one, the today what you have submitted.
Because he has handed over the note today, I had not responded. I had prepared on my own. Therefore, I have not responded, my lords. I have prepared on my own. One of the conditions regarding assessment not being conducted, I have given one judgment of Honorable Gujarat High Court of Justice Pardiwala. As then he was. He has distinguished how the assessment has nothing to do with the source of power of arrest on section 69 and 132. Because that is completely independent.
This student compilation is by the respondent, tied one.
My lord, tied one, my lord.
Yes.
In that,
my lord, I concede, my lord, criminality and assessment goes parallel to. They are, just because there's assessment is there, I can't say that there will be no criminality.
I bow down. That is the problem.
Because 74, section 74 or 73 is independent of 132. 74 and 73 and 74 is assessment. So that is independent of 132. So it will be foolhardy on my part to argue that just because an assessment is made, it's like a departmental proceeding and a criminal prosecution. They're independent. It's just because an assessment is made, there'll be no criminal prosecution is not the rule.
I'm only reading out from the written note, my lords. Yes,
I'm clarifying it. There's no point in
repeating. They have the opportunity to make assessment and issue notice.
Yes.
No,
opportunity. I mean, not a case of assessment, my lords.
No, maybe somebody else has, I don't know whether he was consulted. I mean, he will not, he's not arguing that. He's not arguing that since there is already an assessment, there may not be a possibility of criminality.
And my lord, your lordship has rightly put it, that all further investigation will only add up to this amount.
My lords,
that will not make my prosecution simple beyond 5 years. Supposing, my lord, now it is 5, tomorrow it is 500, day after it is 5,000. Ultimately, it is 5 years.
Yes. Yes, Mr.
So ultimately, had the fake ITC been of amount of 1,000 rupees or 1,000 crores, that should not be in the consideration. If I understand the argument.
Right.
That cannot, my humble.
In fact, that I was telling you, because perhaps you don't have to labor on that. You don't have to labor on that in the enormity and all that. Rather, perhaps the approach should be that whatever is on record, and like much simpler offenses, you can say, though with harsher punishment.
My lord,
simpler offenses with much harsher punishment. The approach is simple. That till now, whatever has been discovered, what is to be there, and what is the punishment, what is the stage of trial.
My lord,
I think
when I was examining this matter in depth, my lords, I was asking myself that why would 5 years only be prescribed for this kind of a transaction?
Then you legislate. You're in Delhi. Please ask the legislature.
Again, because my Lord Senior had a problem, he in Delhi could have come down physically to satisfy Lord Senior. Because last occasion he expressed
5 years, not 5 years. Yes, 5 years. Why 5 years? Why not
5 years? 5 years is not a matter of deliberation here. As far as the court, as far as the court is concerned.
If he has made a study, let him go to the parliament and give a report on that.
Really,
make it 15 years or 20 years or life imprisonment. This is no way.
This is no way to
your personal musings should not be a deliberation in the court. When the bail is being argued, my lord. Why it is 5 years? Why not life? Why not death? So this is no stage.
Obviously.
There's a limit to everything.
Today, actually, I have a meeting.
Yes, my lord. Then, my lord, let it be tomorrow. Otherwise, why should I?
No, let me see that actually, because I'm just looking at the.
Yes, my lord.
On the same terms and conditions?
Same terms and conditions, everything will be same. Only thing, my lord, may be required here that affidavit. I have also prepared an affidavit.
The FIR is same. There is no problem regarding Jani.
No. Your Lordship has already disposed of 2 bail applications in respect of 2 co-accused persons. That's 6243 and 6865.
Today it is 624. Today it is
my lord
1069.
Yes.
42.
Yes.
So 42 is disposed of in terms of the state.
I don't blame my lord. My lord, that affidavit was supposed to be given. That's why I have given.
Line the affidavit on behalf of the petitioner, filed through his wife, is taken on record.
Yes, sir.
Copy has been served. 42 lekhibe. 40 copy has been served on the Lawrence Standing Counsel. Mr. Saugat Das for the petitioner, Mr. Standing Counsel for the state.
Yes. High Lord, my lord. I'm sorry, my lord. After this, sir.
No, we are continuing. We have continued till 6 also. But today there is some other. I have to. I can't do that.
Oblige, my lord.
Yes, please.
I may be pardoned.
43.
43 mein.
Yes.
The last occasion, my lord, already I have filed 2 affidavits. Affidavit 2 further affidavit by the wife of the present petitioner, Divakara Kolas, already filed.
So that affidavit you have received instruction, Mr. Standing Counsel?
My lord, that affidavit, my lord, he has only given the status, not given. My lord has directed to that
status.
I have got the, my lord, got the status of this, my lord, whether we have
Already co-accused person religion bail by this honorable court, so in BLPL number.
Sir, that is well taken, sir. That is well taken. By this court by 8822 and 8976.
My lord.
Yes. So the answer to that for the prosecution is that you are not standing in the same footing.
Already I have filed affidavit.
Affidavit dated?
My lord.
Affidavit dated?
Dated
1710.
My lord.
1710-2023. Affidavit dated 1710.
1710 they have 1810. There are 2 affidavits already, 2 antecedents. I have already filed 1 affidavit. Then this honorable court, the petitioner filed another antecedent. So I have filed another affidavit.
You have obtained instruction regarding that affidavit?
My lord, he has given that affidavit. Another affidavit, my lord, CA is coming, my lord, he is involved in another 302 cases there, my lord.
No, my lord.
No.
So let him verify. I am not rejecting it. I am not rejecting. Don't be anxious that since he is saying 302, I am rejecting it. So let him verify.
My lord, 498, 302, 304B, that case is there. That case is not reflected in the, my lord, affidavit. That case number in para 2 year lordship say that PS case has
no. What he is saying, he has filed 2 affidavits. Are you having copy of those 2 affidavits?
I'm having 1 affidavit.
Yes, my lord.
So you verify that. So he is not having another affidavit.
I have already filed 2 affidavits.
Sir, that is how I am asking. I am telling you that if I have filed, then again serve a copy. If at all you have filed it, please serve it.
Already I have filed, my lord.
So you file it in the registry, or he will make copy of the affidavit.
2 affidavits.
Mr. N.C. Jena, your name is Mr. N.C. Jena. You are Mr.
Nityananda Panda.
Mr. N. Panda for the petitioner, Mr. Standing Counsel for the state.
My lord, the 2 acknowledgements of this honorable court is the 1 acknowledgement of our office. Another affidavit copy is not given.
I have already filed.
आपसे भी बुझू ना थी, Mr. Maybe because of 435, he is not following what he is saying. Sir, you have files and nobody is disputing that. He is also not disputing, but right now he is not having that copy. Have you served a copy in the office of the Advocate General? That he is saying, and you are producing only 1 receipt. The Learned Counsel for the Standing Counsel submits that he shall obtain instruction in response to the affidavits filed by the petitioner on behalf of the petitioner. How much time will require, Mr. Standing Counsel?
Let it come next week. Friday, next Friday.
The instructions will be obtained by
tomorrow. So already
I can dismiss it, sir. Today I can dismiss it. If you are so anxious, today I can dismiss it. Please appreciate the proportion of the submission you are making.
I have already filed, my lord.
Yes, sir. Why you are arguing, going on wasting the time? I am telling you, I can dismiss it just now.
My lord, I'm first affidavit court भी
Sir, Madam Raut, am I telling that you have not filed affidavit? The discussion is something else. You are going in tangentially off track. Am I saying that you have not filed affidavit? The discussion is something else. I am asking for his response. while trying to respond, he's searching for that affidavit. So he has to respond. If you want today, then I can dismiss it, no problem. Are you in anxiety that the matter should be dismissed? Or you want to making a prayer for bail? It is up to you. As paid for list on 13/11/2023. Affidavit copy at flags B and C. You make 2 copies and give it to. Apon par kota achi. Gote 17, gote 18.
18 trach.
17 ta kari diyon. 17 ta ebe kari.
17 ta my lord already court present. Court
Rest of the matters. Rest of the matters apana jota achi.
Translate.
Nani. Kar diyon. Sita to I'll dictate the order. Right now I can dictate some orders, no problem. Mu pacharchi rest of the matters karibe kon. Yes. Specific urgent new item 60. Mr. Khogeshwar. On behalf of Aniruddha Das. On behalf of Aniruddha Das for the petitioner. His Khogeshwar Behera. Mr. Khogeshwar Behera on behalf of Aniruddha Das for the petitioner. Mr. S. Mahapatra for the opposite party. The learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions as paid for list of 15/12/2023.
71.
Ms. Shobhana Das for the petitioner on behalf of S.S. Pradhan. Mr. 71, you are there. Mr. Standing Counsel for the state.
Mr. Kanungo, my lord.
Mr. S.S. Kanungo, Additional Government Advocate for the state. Learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions list on 12/12/2023.
73.
Mr. Khogeshwar Behera on behalf of Aniruddha Das for the petitioner. Mr. 73, Mr. Kanungo is there.
73, my lord, Mr. Naik.
Mr. Devasis Naik, Additional Government Advocate for the state. Learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions as paid for list on 15/12/2023.
75.
Mr. P.K. Barik.
Mr. Naik.
On behalf of Niranjan Lenka for the petitioner. Mr. Devasis Naik for the state, AGA for the state. Learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions as paid for list on 5/12/2023.
79.
Miss Sonali Panigrahi on behalf of the petitioner, on behalf of J. Pradhan for the petitioner, seeks accommodation for to obtain instructions list on 14/12. 79. Yes, next.
89.
Mr. S.K. Mohanty on behalf of Pravas Chandra Jenna. 89.
Devasis Naik.
Mr. Devasis Naik, Additional Government Advocate. Seeks accommodation to obtain instructions as paid for list on 18/12/2023.
90.
Mr. Devasis Sorangi for the petitioner.
Devasis Naik.
Mr. Devasis Naik, AGA for the state. Vigilance is not there. 90 could.
90, my lord. Mr. Naik, my lord.
I'm just checking.
Yes.
Mr. Devasis Naik for the state. Praise for accommodation list on 19/12/23
94
to obtain instruction सबूत से गोटे order कर दियो change करंती order टा so let's save time. Mr. S.S. Rai for the petitioner, Mr. 94.
94 myself.
Mr. Prahara standing counsel for the state. The learned counsel for the petitioner seeks accommodation to obtain up-to-date instruction list on 13/12/2023. Yes.